For judgment, item number 1.
I love the writ petition. We've directed that a sum of rupees 10 lakhs be paid to both the petitioners each for the death of the two respective little children in the tragic circumstances and falling in a rainwater filled pit inside the Anganwadi center in a school. We've also issued directions to all collectors of the 30 districts in Odisha to ensure strict compliance with the directions of the Supreme Court in its judgment in measures for prevention of fatal accidents of small children, and extend those directions not just to borewells or tube wells, but even construction sites and other places where it is likely that young children might meet with fatalities for lack of awareness and adequate safety measures. A copy of this order shall also be sent to the State Commission for Protection of Child Rights and the NCPCR for information.
For mention. for fresh admission. Item number 2.
Praying for your lordship, sir. Indulgence, my lords. In yesterday's matter, my lords, I want to pray for your lordship's leave to file a supplemental note of submission.
All
Short-
right, all right. Do
short
that,
one.
do that.
I'll serve it up. Obliged.
All right.
My lord, this writ application of petition challenges the annexure 3 issued by the opposite parties for return of the compensation amount. The fact is that some property was of the petitioner was acquired. For that reason, petitioner was awarded amount 1 lakh something, and after the expiry of 6 months, 5 months, the again a notice was issued to the petitioner to return some amount from the compensation amount. For that reason, the petitioner has come to this court. My lord, similar matter, my lordship has passed an order to dispose of the writ application 19062. Similar.
Who's for the other side?
My lord, I am for the other side, my lord. This is that particular case where refund notice was challenged earlier, your lordship must be remembering. But in the instant case, if your lordship find the prayer at page 8, your lordship may kindly see page 8. There are 2 prayers. First
Correct.
prayer is to forward this section 64 application to the appropriate authority for adjudication. That is the first prayer.
First prayer is notice should not be quashed. Annexure 3 notice.
That annexure 3 to be quashed, and the prayer is to send the section 64 reference to the concerned authorities.
Right.
So far as section 64 recommendation is concerned, there is no such annexure in the writ petition that he has filed this section 64 application and that was not referred to the concerned authority. Your lordship can say because we are not stopping that. Anybody is coming with section 64, we are just referring to this. So far as the refund notice is concerned, your lordship has already ordered that they will make a representation to the collector. Collector will take a decision on that matter, and that decision is again challenged. Your lordship must be remembering in the case of
Yes,
Mr. Vidyadhar Mitra, senior advocate.
Correct. You see, there are 2 prayers in the present petition. First is for challenging a notice. It's all in Odia. What's the date?
Notice dated 4th May 21.
4th May 2021.
To
Issued,
refund the excess amount paid to the excess
issued by the land
compensation
acquisition
amount.
officer, Civil Cuttack, asking the petitioner to refund the excess amount of compensation. Paragraph. As regards this prayer, in light of the order already passed by this court on 15 July 2021 and writ petition civil 19162 of 2021, it is directed that the collector will examine it.
My lord, yes, my lord.
The collector will examine the correctness of the above notice and after hearing the petitioner pass an appropriate order thereon not later than 15th November 2021. This order will be communicated to the petitioner not later than 22nd November 2021. If the petitioner is aggrieved by the order, it will be open to him to seek appropriate remedies as may be available to him in accordance with law. Paragraph. As regards the second prayer, which is for a direction to the collector, a direction to the land acquisition officer
Land acquisition officer.
to make a reference to the collector.
To the R&R authority, my lord. L
Sorry.
and RR authority.
To the competent authority of the under section 64 of the right to fair compensation in land acquisition, rehabilitation, resettlement act 2014. It is not clear from the petition whether such an application as in fact the petition does not enclose a copy of the application made by the petitioner. Stop. If indeed such an application has been made, a direction is issued to the collector, bracket opposite party number 3, to make the appropriate reference not later than 15th November
My
2020.
lord, there is a time-bound schedule as per the law. Within 46 days, we have to send the reference within 46 days.
Yeah, to make the reference, if not already made, in accordance
In
with law.
In accordance with law. Yes.
For implementation of the directions issued in this order, the petitioner will produce a downloaded copy of this order before the collector. That is opposite party number 3, not later than 11th October 2021. The petition is disposed of.
Obliged, my lord. Obliged.
Item number 3.
May I please, your lordship? My lord, the petitioners in this case have prayed for a direction to the OP number 2 to consider their representation regarding the encroachment of a government land in the government land by OP number 4, my lord.
Now, who are the encroachers?
My lord, OP number 4, my lord. It is
All right.
Kailash Chandra Maharaj.
All right. Annexure 3 series is your representation, is it?
My lord. My lord, I have also filed a IA, my lord. In the meanwhile, the encroachment is in the nature by constructing a concrete house on the said land. I have also annexed the photographs, my lord. At Annexure 2, my lord. My lord, right now the pillars have been erected and the roof has not yet been laid. And my only prayer is that till the matter is finally disposed by the OP number 2, no further construction be made.
Tal chair.
My lord.
All right.
Lordship may direct the Tahsildar, my lord.
All right. You see, a direction is issued that the petitioner's representations dated 13 July and 11th August 2021 shall be examined by the Tahsildar. Talche, bracket opposite party number 3. And after issuing notice to the petitioners as well as opposite party number 4 and giving them a hearing, a reasoned order shall be passed not later than 6th December 2021 and communicated to the parties not later than 13 December 2021. The court makes it clear it is not expressed any view on the contention of the petitioners. It will be open to the Tahsildar to pass appropriate interim directions that may be sought by the petitioners, if warranted in law. If agreed with the order of the Tahsildar, it will be open to the parties to seek appropriate remedies. The petition is disposed of in the above case.
Item number 4.
May it please, Milords. Milords, this is a matter, Milords, where my refund application is pending since 14th of November 2019, Milords. That matter, I have a limited prayer, Milords. A direction may be issued to dispose of my refund application in a time-bound manner.
All right.
Annexure 1.
Mr. Mishra?
Your Lordship.
All right.
Your Lordship, Annexure 1 may be disposed of as per law, Your Lordship. Your Lordship may not, on the merit, Your Lordship may not say
Yes,
anything.
yes. All right.
Your Lordship.
A direction is issued, given the limited nature of the prayer. A direction is issued to the opposite party number
2, Your Lordship.
Two,
that is
Milords.
the Deputy Commissioner of Commercial Taxes, Jagat Singhpur, bracket opposite party number 2, to dispose of the, if not to dispose of, if not already done, the refund application of the petitioner for the period 1st April 2007 to 31st March 2012 in accordance with law by reasoned order, not later than 20th December 2021, and communicate to the petitioner the said order not later than 27th December 2021. The court clarifies it has not expressed any view on the contentions of the petitioner. The petition is disposed.
Milords, there may not be any order required, Milords. They just have to issue the refund.
No, Your Lordship. There is some procedure, Your Lordship, for issuance of refund, because it is not automatic from the return, Your Lordship. So some procedures are there.
Very well. Very well.
Your Lordship, if necessary, the petitioner may cooperate with the assessment officer.
Of course.
Yes. Yes.
Right.
Item number 5.
Same order 5.
Same for the period 12 to 17.
All right. So only the period will change. All right.
Item number 6.
Annexure 1.
Annexure 1.
Correct.
Grateful, Milords.
All right.
Item number 6.
My lord, this is a matter regarding land acquisition. My lord. This is a matter regarding land acquisition. Petitioner made grievance before the collector from special land acquisition officer. Opposed by not 2, and the grievance is under Annex 4, my lord.
Lord, your lordship may see the dispute is purely civil in nature. Because
No.
in paragraph 2,
No. Also, yes.
The allegation of the petitioner is that the opposite party has illegally mutated the land in their favor.
No,
and
but
therefore-
anyway, you just have to dispose it of. When was the acquisition? When did the acquisition take place?
My lord,
Opposite party number 3, zone officer
No,
directly gave a notice to petition number 2 for hearing.
opposite party number 2, my lord.
Huh. Correction of ROR and all, you have to do, have separate proceedings, please. Come to para 9. That whole allegation, para 9, I think you have to seek other appropriate remedy. Just see para 9.
Yeah, my lord.
Have you seen para 9?
I see.
So your allegation is that the ROR was corrected without obtaining permissions and without notice to the vendor, as it is a scheduled caste land.
My lord.
So there are other proceedings for getting the ROR rectified.
The back and behind they got the ROR corrected.
Can you just find out what is happening here?
Well,
Mr. Das, appearing on advance notice, states that he needs time for instructions. List on 15th December.
My lord, direction will be given to the collector to consider.
First, let him find out, sir, what the facts are. Right.
For orders. Item number 7.
My lordship, my lord, in this case, the appellant is convicted under section 376(2)(f) of PC and sentenced to RI for life and 2,000 fine, lordships. My lord, he is in custody about 10 years in jail custody, lordship.
Yes.
So before lordship, my lord, that the accused committed rape on a minor girl of 5 years age, my lord.
Yes.
And my lord, admittedly, she is minor, my lord. And the
Yes.
accused person also, my lord, injured at the time of 19 years age, my lord, at the time of occurrence, my lord. And he is already, at the time of occurrence, he has taken alcohol in the mess, and under influence of alcohol, he committed rape on the my lord. This is my submission before lordships. And
Right.
in the meantime, my lord, 10 years old custody, he is a young person, and similar matter that Honorable Supreme Court has reduced to 10 years, it RI for meet to end of justice, lordship. So my respectful submission, my lord, let the sentence may be reduced, and my lord.
Where is the Supreme Court judgment?
Yes, my lord. 2012, 2 Criminal Law Journal 1573, Supreme Court, my lord.
Where is it?
Yes, I will give my lord. I will give the office. I will give the office. My lord.
Then we'll pass it over. You better send it. Pass
Yes,
it over.
Yes, my lord.
Item number 8. Item number 8.
Item 8, may I please, I'm appearing for the state, my lords.
This is 304 part 2.
Yes, my lord, but the sudden provocation was that he has gone back and he has again come back with an axe. So your lordship can consider that.
All right. But on the neck. This is on the neck.
On the neck. One blow,
On the
sufficient
neck.
cause death on the neck. left-hand side take. And eyewitness is the wife is the immediate eyewitness. I mean, she's the eyewitness, and
Right.
3, 4 are the immediate post-occurrence witness.
Who's for the appellant? All right, pass over.
Item number 9.
Item 9 made legal. I am appearing on behalf of the petitioners, madam. Madam, may kindly see the order dated 3rd September 2019-21. This matter, your lordship, Annexure 1 is under challenge. Annexure 1, your lordship, can have a glance in respect of the other original applications. Repetitions were filed, and those repetitions were dismissed. Therefore, the state had gone to Supreme Court, and Supreme Court directed to seek review of the order. And then those batch of review petitions are pending before your lordship, and your lordship adjourned those review petitions to 12th of November, madam. Here, this matter
November, is it?
12th November, your lordship adjourned those review petitions pending before the another bench, my lord, because that bench, my lord, your lordship and my lord Justice Mahapatra was there.
All right. You say list along with
review petition 22 of 2021.
All right. On
and other batch cases.
Other batch of cases on 12th November. All right.
Item number 10.
My lord, I am for the
May I audible, my lord?
Yes, yes.
My lord, the petitioner is the superintendent of, the Chief Postmaster General of Orissa, and the director is another appellant who challenged the order of the Land Central Tribunal dated 11/9/2019 under Annexure 1, page 28 plus 28, wherein the Land Central Tribunal has observed that in para 9, let's see the para 13, page 30, running page 31, my.
Yes.
May I read, my lord?
Yes, please.
In view of the above discussion and taking into account of the facts and circumstances of the case, we dispose of the OA with direction to the respondent number 2 to consider the impugned charge sheet dated 19/7/2016 under Annexure A/3 and pass a speaking order as to whether the proceeding against the appellant are to be continued, and if so, the charge against the appellant be approved by the respondent number 2, taking into consideration in impugned charge sheet dated 19/7/2016 under Annex A/3. The copy of the order of respondent number 2, as above, is to inform the applicant within 60 days from the date of the above, date of receipt of this order, and till then, no action in response to the charge sheet dated 19/7/2016 under A taken by the respondent. Against which you have agreed, my lord, the CPMG has a competence to issue charge sheet against the person who is making corruption in the department, giving appointment to 17 GDS without approval of the authority, and the meritorious person those have in the list, they have been ignored. This is the small issue before my lord. So whether the tribunal has passed such order, even though the CPMG has proceeded for charge sheet, in this stage, can the tribunal intervene? Your honor?
No, but tell me one thing, this order was passed on 11th September 2019.
My lord.
Until date, no stay, nothing. So what have you done?
But my lord, after this order, after getting this order of the Land Tribunal, the university has preferred to file this writ petition before my lord in the month of August, because this period of COVID, my lord. And in that period, it was filed, but it could not be listed.
COVID started only in March, sir. March 2020.
Yes, yes.
The order was passed in
my humble prayer before my lord.
2019.
Yes, yes. Okay, 2019.
So you did nothing. This could have been over long ago.
No, my lord, but here
it was a time-bound direction, correct?
Within 60 days.
So all that 60 days got over in November 2019 itself.
Here is the issue, my lord, to decide whether.
See, all those neat questions of law can be left open. You've just allowed this unnecessarily to linger now for 2 years.
That's why the charge sheet was issued. Let them appear, let them file their focus. Proceedings go on. There is no bar. Say, they are saying that no, you cannot.
Let's see what the direction is. The direction is to respond number 2, to again consider the charge sheet, pass a speaking order whether proceedings are to be continued. If so, charges to be approved. Why
Yes.
can't you do all this? If you're so clear about the
My lord,
charges,
there is no
what
need
is
for
the
approval.
problem?
The CPMG himself, here is the case, what happened. I thought the Learned Tribunal has not taken into consideration that here is we are giving charge sheet against the superintendent of post office. He is the one of the person who is heading the particular division, my lord. And this CPMG, the competent authority to issue charge sheet to them. After punishment, there is a need to get the approval from the director, from this central director in this regard. But before that, after for issuance of charge sheet, there is no need to take permission. Rule 13.2 of CCR is very clear.
No, the point is this, Mr. Padi. If you come immediately after these orders are passed, it has some meaning. You're coming after some 2 years. You're filing it itself after 1 year.
No, my
You're
lord.
getting it dismissed after 1 more year. You're allowing 2 years to go by. Nothing happens.
My learned
Everything is in
predecessor
limbo.
has filed on 3/10/2020. It order was passed on November 2019.
No, September. This order is passed in
Sorry,
September
sorry, my lord.
2019.
September, yes.
Almost 1 year later, in August, you file the petition.
Yes.
And then 1 more year later, you bring it up for hearing.
So, Lordship, clarify that point.
We leave all this very important questions of law. We leave it all open. You better implement this order and be done with it now.
My lord, but
otherwise, this will simply drag on. This will simply drag on. Nothing will. You are going to achieve nothing. See, if you're so clear about the charge sheet, opposite party number 2 will approve it in no time.
But here is the again I am Lordship.
No.
There is no need to take permission to anybody, my lord, giving the charge sheet. This is the whole thing, sir. My lord, tribunal has observed.
We will leave the question of law open. We will say it will not constitute a precedent. All right.
Yes. That yes.
You say the limited direction issued by the Central Administrative Tribunal, Cuttack Bench, Cuttack, was to direct the opposite party number to direct the Director General, Department of Posts, who was respondent 2 in the OA number 95, 2017, filed by opposite party number 1 herein, to examine the charge sheet issued to opposite party number 1 by the Chief Postmaster, bracket, who was respondent 3 before the CAT, bracket. And if he found the charge sheet to be, and if he was approving the charges, then to pass a speaking order and then thereafter inform the respondent number 1, opposite party number 1, within 60 days. Until then, no action to be taken on the charge sheet issued to him. Paragraph. The contention of the petitioners is that the CPM was perfectly competent to issue the charge sheet, and there was no need for the DG to approve the charge sheet at this stage. Paragraph. Fact of the matter is that the above time-bound direction was issued way back on 9 September 2019, and more than 2 years have passed, full stop. It appears that no action was taken to implement the impugned order, although there was no stay by this court, full stop. All this has resulted in the matter needlessly lingering on for over 2 years. Paragraph. In the circumstances, the court is of the considered view that the interest of justice would be met by directing that the questions of law raised by the petitioners in the present petition would be left open for consideration in an appropriate case, and further that the impugned order of the tribunal will not constitute a precedent. Full stop. With the above observations, this court declines to interfere with the impugned order and disposes of the writ petition.
Item number 11.
My lord, may mention the Mr. Marana who is appearing with me.
All right.
Land CGC.
All right.
May I please, your lordship? Well, here the state is the appellant, challenging the ex parte order dated 10/2/2020 passed by the Honorable Single Judge. Your Lordship, may kind down to page 37.
Who's for the other side?
Your Lordship, can page 37, order number 2 dated 10/2/2020.
I know. First day order. Correct.
Yes. And your Lordship, can same page, last paragraph. Considering the contentions raised by the Lord Counsel for the petitioner, and after going through the records, it appears that the petitioner has rendered service for more than 25 years on DLR basis. Therefore, the case of the petitioner.
But again, you not explain any no reasons for the delay. When did you get the certified copy?
Yes, my lord, we received the information on 8/3/2021.
Oh, sir, look at the date of application, date of notification. Just come to page, that stamp is there, page 39.
No, that is the copy of the order, my lord. That is not the certified copy. That is why we have filed an IA for dispensing with the filing of certified copy for the
You
time.
had that copy you had in February 2020 itself.
That is a Xerox copy.
Whatever, sir. You have a copy with you.
No, these we received.
If you are filing an IA for exemption,
yes,
then you can file it immediately on getting the same Xerox copy.
No, these Xerox copy we received on 8/3/2021. Your Lordship, may kindly see my application under section 5 of the Limitation Act.
All right, you say notice on that application, notice on the main petition, returnable 29th November. Notice be served on counsel appearing for the petitioner before the Lord Single Judge additionally. Right.
In the meantime, also, Honorable.
Is there any contempt filed?
No, there is no mention in the state.
Then there's no need for anything. Notice and stay also. All right.
Because that
We'll probably remand it, Mr. Budli. That's what's going to happen. Yes.
Yes, Uma Devi 3 has also been explained in latter judgment of University of Delhi case.
Whatever.
And
Let
on
the other
the
side
date
come.
of judgment, if the applicant has not been appointed by following the due process of law, and if he has not completed 10 years of service.
To both a forester, my lord, he is
better to go to a forest area, sir.
No, sir, he was there for 20 years there.
Oh.
So, as per his representation, he was transferred to Cuttack Division. Again, it has been transferred by a person who is not competent to transfer him.
No, anyway, what is the impugned order is what? 6th August.
But it is just for disposal of the representation.
So what's wrong with that?
My lord, in case of a transfer, if his representation is allowed to be disposed of within giving them 3 months time, then my lord, your lordship can see that it will be completely infructuous. The petitioner is on leave, and if he is
let him join, sir. From Cuttack to Baud is no big distance.
Yes, ma'am. Cuttack to Baud is more than 300 kilometer distance. And his, from his place of posting, it is more than 400 kilometers.
How long was he in Cuttack?
Cuttack only 2.5 years, man.
Only 2.5. I think that's
yes,
enough. In government service, 2.5 is long enough. You have to keep moving.
But there he was there for 20 years, my lord, where he has been transferred. Moreover, my lord, when a person is not competent to transfer the person, it will not be justified to allow that transfer by an incompetent person.
My lord, I am to the state. Lord, the impugned order in the reveals that the petitioner himself withdraws the writ petition with a prayer to dispose of his representation, my lord.
Achha.
Now, this order was passed on 6th of August, and my lord, the petitioner filed the writ appeal on 6th of September, my lord. So, my lord, he waited for 1 month to, my lord, for disposal of his representation. And secondly, my lord, as your lordship knows, my lord, in the transfer matter, the scope of judicial review is very limited. And my lord, I'm just relying.
No, he's not withdrawn. Just see the impugned
my
order.
lord, my lord.
1 minute, 1 minute.
My lord.
He has not withdrawn. Just see the impugned order.
It was disposed of, but on his own submission.
No. That he has filed a representation, he said.
Yes. But may I just,
Sir, will it help you if we say the representation disposed of by 15th October?
My lord, by the competent authority, this transfer order is completely
No, now
invalid
that
and
scope is
irregular.
gone. That
My lord,
doesn't matter now. Somebody has to consider your representation. We'll shorten the time for considering a representation.
my lord, your lordship.
All right. The impugned order requires the opposite party number 1 to consider the petitioner's representation against his transfer within a period of 3 months. Paragraph. Counsel for the appellant states that such a long time for disposal of representation would render the prayer infructuous. That way, the matter, the impugned order is modified only to the extent of requiring opposite party number 1 to dispose of the petitioner's representation by a reasoned order not later than 15th October 2021. A copy of the decision would be made available to the petitioner within 3 working days thereafter. The appeal is disposed of.
Item number 13.
A copy of this order shall be communicated by counsel to the opposite party number 1 forthwith. Yes.
May I please be for
Well,
I am appealing for the respondent opposite party state 6 appeal to appeal against acquittal, my lord.
You have to speak louder and into the mic, please.
My lord, the state 6 appeal against the acquittal, my lord. I humbly submitted, my lord, the petitioner, the accused, my lord, is on all along bail during course of trial, my lord. After acquittal, married to the victim and blessed a female child, my lord. They lead a happy conjugal life. And in the meantime, my lord, the state filed an appeal and a warrant has been issued.
Yes, my lord. I'm appealing to the state, my lord. So we have challenged this order. Basically, 2 grounds, my lord.
Yes.
That the learned court below has disbelieved the version of the prosecutor and has relied on the medical report saying that absence of injury on the private part has on that basis has disbelieved the statement of the victim. Secondly, there is some discrepancy regarding the filing of the FIR or the arrest of the accused. But admittedly, it is a occurrence which happened in the house of the victim, where he was caught red-handed. He was restrained by the family members and was handed over to the police. And the consent part has been ruled out, admittedly, because she is a minor. She was 14 years of age, as her medical birth certificate showed, my lord. So here, my lord, there's a 164 statement of the victim also, where she has kept very elaborately and in
Same order. Same order. Disposed by the same order. Right.
Item number 15.
14, I am appearing for the state.
All right. All right. Yes.
Yes, I will kindly pardon for small interruption, my lord, very small interruption. The previous matter, your lordship, I could listen to your lordship. Your lordship disposed of this petition or only I am yours?
No, dispose of the writ petition.
Yes, sir, it requires little clarification. Little clarification. In view of orders passed by your lordship, minutes, the annexure 11 minutes must be set at rest minutes. Otherwise, minutes, there will be two operative orders. Just that is little clarification. Yes, in view of orders passed by lordship minutes, annexure 11 may be set at rest minutes. Because otherwise, that may impact because your lordship, there is no tribunal and your lordship has to decide the matter. And the similar situation is there in both the cases. So, in view of already your lordship passed the order, annexure 11 may kindly be set at rest. Only this clarification only.
Set at rest means what?
Rest means no further order is required to be passed minutes. In view of order your lordship have passed minutes.
Who's Mr. Chimanka?
Little clarification will do.
No, but is Mr. Chimanka there?
My friend is there. I tried to contact him. He is there in the court, minutes.
No, he has left. You have to call him. Then you mention it again at 2 o'clock.
2 o'clock, obliged.
Item number 22.
You shall order.
Item number 23.
May I please, Your Lordships?
Yes.
Your Lordships, in this matter, I have challenged the so-called notice under section 74 and the subsequent order of recovery under 79. But recently, Your Lordship has been pleased to pass the order in WPC 25484 of 2021. I have supplied the copy before the court master today. So I will move the appellate authority and he will consider my application for removal of the bank attachment and everything. I will deposit 10% of the amount, Your Lordship.
All right.
May I say, my lord?
Yes, Mr. Padi.
Here, my lord, I must say the least the petitioner is guilty of material facts, my lord, because the notice he has challenged, thereafter attachment order have been passed, and more than a year thereafter the attachment notice which is impugned herein has been passed, my lord. So without, he simply annexes the so-called notice and files the petition making a statement that no order, assessment order has been passed. In the meantime, my lord, if your lordship will permit, I can screen share. Assessment order has been passed in 2020. More than a year, this present attachment notice has been issued, my lord.
I see.
My lord, material fact, my lord, is not come with clean hands. And all these orders are in his portal, my lord. He can, if he has assessed this so-called notice, then he could have assessed, my lord, those assessment orders. There, in that order, 74, that's a so-called notice, my lord.
Yes, Your Lordship. This is a so-called notice.
Here, assessment order have been passed, my lord.
But kindly,
my lord, in 2020.
Your Lordship, kindly have a glance on the recovery order on 79, Your Lordship, under Annexure 2, Your Lordship. Page 23.
Yes. Yes.
And if I can point out, my lord, 25, that's the annexure to this attachment, page 25.
Yes.
Yes.
My lord, may come towards the particulars of the defaulter, then thereafter, demand order. My lord have got?
Yes.
Demand order number so and so dated 21/10/2020. So on this date, this assessment order was passed and demand was raised, my lord. He has suppressed all this. A year after this attachment notice has been issued. And it's a regular attachment. It's not a provisional attachment as has been avowed by the petitioner in the entire petition and all the.
So no appeal has been filed against this assessment order.
No, Your Lordship, that is not in my knowledge, Your Lordship. Your Lordship may direct me to approach the appellate authority by because the so-called notice demand is already confirmed in this. What my learned friend is saying, that means it is already confirmed in the order.
Withdraw this petition with liberty to file an appeal along with an application for interim relief.
Yes, Your Lordship. Yes, Your Lordship.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to file an appeal against the demand order at the original assessment and the consequent demand order dated 21st October 2020 in accordance with law.
Your Lordship, kindly observe that. Delay condone and the bank attachment, everything I will replace
If such appeal is filed not later than 1st November 2020, accompanied by an application for condonation of delay, the explanation offered by the petitioner for the delay in filing the appeal on account of the pendency of the present petition will be taken into account by the authority in accordance with law. It will also be open to the appellant to seek appropriate interim orders in the appeal in accordance with law. The court makes it clear that it does not express any view on the merit, on the question of merits or on limitation. The petition is disposed of is drawn with liberty is paid for in the above terms.
Yes. Only, Your Lordship, kindly observe that bank attachment, for the bank attachment, I will approach the...
Whatever I said, appropriate interim orders. All right.
Yes, Your Lordship.
Item number 24.
Obliged.
May I please, Your Lordship? My Lord, petitioner daughter was found missing from 22/7/2021.
All right. We'll just say notice. Who's accepting notice?
State.
No.
I'll accept notice.
All right. The status report we filed before the next date. List on 2nd November.
For admission, item number 25.
Mr. Ray.
Yes, ma'am. Well, it's at the outset, I'll submit that I am not challenging any constitutional validity of the provisions.
All
but
right.
I am challenging the notice on a very limited ground. Lordship will kindly turn to Annexure 2.
No, before you start, Mr. Ray, there are 2 review petitions. What are those?
No, I have not filed, madam. That department has filed, and in spite of Lordship direction to serve the copies of the review petition, they have not yet served the copies of the review petition.
That is not in this case, my lord. That is something different.
That is different, my lord. That is
different matter, and my lord, Justice Chief Justice
segregate those two.
Has passed the order.
Oh, so those 2 review petitions have to go.
Be deleted.
Have to say segregate it.
All right. This review it's already stands deleted.
Sorry.
It has to be deleted, right?
Yes.
That has
not yet been admitted. Lordship can take up next week. It can be.
All right. You say this review petitions 188, 189 of 2020. These be listed before the appropriate bench on 5th November.
Right.
Yes.
Now, my lords, Lordship may kindly turn to page 15, Annexure 2. Lordship, that is Panchanama. And your Lordship will find clause 5. In the course of the search, the followings were found and seized. Nothing. No books of account, no bullion, gold, silver, nothing of the sort has been found. Or
have you not passed a similar order in some other matter?
Yes, my lords, that is I have given. That is Jami Nirmala. Your Lordship have disposed of in this August. I have already given, my lords, the copy of the judgment delivered in 2857 of 2018, where your Lordship dated, I think date is 10th of August 2021. And there, my lords, Lordship have followed the judgments rendered in Kabul Chawla and also Mita Gutgutia, and also in the case of Gujarat High Court, and the judgment so far as Principal CIT versus Mita Gutgutia, reported in page volume 395 ITR, page 526. This position, if nothing has been unearthed, nothing has been seized, then the notice to reopen, these are all reopening of the assessment. So 6 years from the date of the search and the year on which the search is conducted. You cannot reopen it. 153A is not applicable. And I have also submitted a written submission and enclosing all the judgments of different high courts, including the Kabul Chawla versus
yes. Let me ask Mr. Satpathy. Yes, you've seen the Jami Nirmala.
Yes, just now he has given the copy. But here his fact is slightly different. Here his notice has been issued, he has participated in the proceeding, and your Lordship has an order has not yet been communicated. So whatever he has grievance, if this judgment is applicable to this case, let him appear before the case. If it is fit to the case,
it's a 2009 matter.
Yes,
no point. If the law is so clear, no point now sending it back.
Lord. I am just submitting, Lord. He has not challenging now the virus. that part he is considered not.
Correct.
So far as the notice, he has already participated in the proceeding.
But
If
why
after
go through
participating in
this?
proceeding,
Since-
and if not, he says that this covered by this one, just now I received this order just now. So I heard a humbly pray subject to your lordship, what falls for lordship. Your lordship direct that he will appear before the authority and place this judgment. If it is applicable, let the assessing authority pass the order in accordance with law. So, yeah, what I am just submitting, Lord. I am just this is my suggestion. Lord. It's subject to what it falls from lordship. Or lordship give me 1 day or 2 day time, I can go through it and take instruction on this issue, Lord. I am not because he is squarely, Lord. Now he changes his track. Now initially he is challenging the
Track. That second prayer is there.
Yes, second prayer is there.
You're only giving up one prayer. The other prayer is very much there.
That is what my predicament is that you will lordship that objection not to dispose of.
Or simply
You can
reserve
solve
order,
all the
you can
purpose.
file your written
Because the assessor cannot go beyond your lordship direction. If your lordship observation dispose this matter and directed that if it is covered by this judgment and is placed this case, it is covered, then it's passed the order, Lord.
Why go through that? It's
No.
been pending since 2009. If you had just come for the first time today, we would have done that. For 11, 10, 12 years, it's pending here.
Yes, my lord.
Ah.
I have before
We just
I have
go-
received the
we just adding to-
brief, my lord. I filed the counter. My lord.
No. It's a 2009 matter.
yes,
Where's
but
Mr. Counter and all now?
The copy of it was listed then. I
No,
received the
9
copy.
July. See,
My lord,
you passed the order in your
somebody-
presence
yes,
on 9
somebody else must
July.
have- Somebody else must have appeared. But
No.
So far I am concerned, my lord, I have received on previous date. That is my predicament, Lord.
No. 9
lord,
July, you were there. You were there in 9 July. Today we are in September. You had enough time. In fact, even if he had not produced the orders by this written submission, you should be aware of these orders.
Yes, my lord, but it has not been. I have not seen that. My lord.
See, at the highest, what we can do is we'll reserve orders. If you have to file a written note, you do it.
Yes, my lord.
Ah.
Yes, that.
Orders reserved, it will be open to the council for the revenue to file a written note of his submissions. Within 1 week?
Yes, yours.
All right.
Item number 26.
May I please, Your Lordship? On 25th of March, Your Lordship had called upon the petitioner to file an affidavit as to when he came to know about the impugned order. I filed the affidavit of compliance on 16th of April. 16th of April 2021, I have filed the compliance affidavit that in paragraph 2 thereof, I have stated that by letter number so and so dated 5/4/2010, the district office of the Special Land Acquisition Cell, Jagatsinghpur, informed the managing director of Petitioner Corporation about the impugned order passed in remand revision case number so and so. A true copy of the letter is annexed as Annexure 11. On getting such information, an inquiry was conducted and the relevant papers were obtained. The certified copy of impugned Annexure 8 was made available to the petitioner on 7/2/11. The petitioner corporation has thereafter examined the orders and that have been passed with detriment and decided to challenge the same. And this was writ petition was filed immediately thereafter.
All right. Yes, Mr. Jaina?
Yes, my lord. I am from the opinion note 6, my lord.
Yes.
But the order was passed on, kindly see Annexure 8 on 18/1/2003.
I know.
By the issue.
I think
Then
for
my
some
lord,
reason, yes.
I am agree. Then, my lord, your lordship had asked the government advocate to cause products of the record why it was intimated to it was after a period of 7 years. Your lordship had called for the record.
Yes, who's for appear for the government? Last time it was Mr. Sahu. Mr. Sahu. Yeah, he may not be appearing. We'll have to wait then for some other date. Mr. Katkar is there?
I will inform him. I will inform Mr. Sahu.
All right. You see,
Okay.
Mr. Mukherjee refers to the affidavit filed by the petitioner on 15th April 2021, explaining the delay in approaching this court. So, in particular, it is stated that an intimation regarding the order passed in the remand revision case number 1629 of 1998 was sent to the petitioner only on 5th April 2010 by the Special Land Acquisition Cell, Jagat Singhpur, paragraph. On the previous date, the court had required the relevant records to be produced to see, to find out why there was a delay in the communication of the above order to the petitioner. Stop. Today, for some reason, Mr. Sahu is not available. Mr. Sahu and AG is not available. Mr. Katkia states that he will seek the necessary instructions and produce the records on the next date. List on 20th January, 20 January 2022.
Obliged.
Item number 27.
In this case, earlier it was directed to be listed on 30th November.
I see.
And day before yesterday, they have served the counter and I have to file the rejoinder.
All right. Rejoinder be filed before the next date. List on 30th November. All right.
Item number 28.
Both. Same, both.
Once, 28 also.
Item number 29.
No, item 29, I am appearing for the registry matter. Today I am filing the written note on behalf of the registry.
All right. Mr. Mudali informs the court he will be filing his written note of submissions today.
No, may I request the court master to hand over the copies I have already filed.
All right. Say Mr. Mudali has filed the written note of submissions today. You have served a copy to the other side?
Yes, my lord. He is not available in the court. I will supply the copy in course.
Yeah, he undertakes to supply a copy to the petitioner within 3 days. List for final hearing on 14th December.
It's item 26. I may be pardoned. I will have prayed for time in any event.
Yes. We have anyway. Yes. All right.
Item number 30.
Please, my lord. My lords, at flag F, an affidavit has been filed and that is served on me on 9th of September 2021. And my lords, I need certain instruction in the matter. In the event I get the instruction, I may not press this result. I want some time to get instruction.
All right. The affidavits, Mr. appearing for the petitioner states that he needs to take seek instructions on the affidavit filed by the interveners on
What's 9
September 2021. At his request, list on
short date maybe. Let us short date maybe
10th November.
Item number 31.
May it please, my lord. My lord, before beginning, my lord, I want to bring to your lordship's notice that yesterday only they have filed along with a memo, a sketch map, my lord, in response to my affidavit dated 24/8/2021, even though your lordship directed that affidavit is filed much earlier.
No. My lord, may I be with the kind permission of my learned senior. My lord, the entire contention which has been noted in the order dated 7/7/21, my lord, is that if this denotification is held to be good, and because the petrol bunk of which I am an allottee that is coming up at the place, their burden of the song was that the petrol bunk, my lord, is coming at the entrance of the factory. That's why, my lord has been kind enough to take note of their submissions, and by order dated 7/7/21, order number 19, my lord kindly sees paragraph 3. Your lordship have categorically asked them to file an affidavit to show that whether this petrol bunk will affect their entry to that factory or not, of which they have not, of the land which they have not taken possession at all. By way of memo, my lord, I have filed 2 maps. One map is the map which they have submitted to the IDCO. It is their own map. Not that I have given any map. It is their own map
which is as enclosure A I have filed, and enclosure B, my lord, for convenience of reference, only the disputed area I have marked. I am only relying on their maps. I am not given anything else. Now, my lord, Indian Oil, everyone has come up with their cases.
All right.
It has nothing to do with their factory, of which they have not taken possession at all.
All right.
My lord, because of the litigation, my lord, I am suffering, my lord. No one else is suffering. That is what I am praying, my lord.
You have to suffer once you purchase the land in 2011.
That's a different issue. But the Honorable Court's indulgence was short because my learned senior was not properly instructed.
Yes, all right, you have made your submission. Let me now say.
No. I am the only person, my lord, who is suffering. It is the luxury litigation for them. My entire life saving is there. My father is bedridden, my lord. It will not affect anyone. Without claiming equity, your lordship may vacate the stay order. That is what I am saying.
Somebody commits a wrong,
they don't have
because of the wrong
not there at all. The DPCL has filed an affidavit that it doesn't affect them at all. Their own map says it doesn't affect them at all, my lord.
Will you allow me to speak, Mr.
No, I cannot dare.
Yesterday they have served a map. Yesterday only.
The map they have served is supposed to be a master plan. Your lordship may have a glance, there is no plot number, nothing. I have given a sketch map along with the details of the plot number and other things. He has marked it one yellow person, he has marked saying that this is my yellow person and leaving two open spaces in both the sides without mentioning the plot numbers and other things. And the person, the director who was looking after the case, we tried to contact him. His father has expired and he has gone to that Allahabad and Goya for the rituals. So he is not available. Now, what prevented them from filing that map? Even though I gave that affidavit on 24/8, probably 24/8, right, for all these days. And knowing fully well that the matter is coming up today, then yesterday serving a map, that is one thing your lordship may kindly take into consideration. So far as the sympathy factor and the sympathy card that Mr. Narsinga is trying to play, my lord, your lordship will kindly appreciate that section 44 notification was done in 2007, my lord. Then section 7 notification was done on 1903 2008, that section 6(2) notification, my lord. Then opposite party 5 and 6, they purchased the land on 12/10/2007. They challenged the notification before this honorable court, lost. Then 2008, my lord, then 17/3/2010, I am directed to deposit the entire amount. I deposited 7 crores, 3,18 rupees. Then on 34/10/2000, sorry, my lord. Then, my lord, they purchased the land, my lord, after those opposite party in 2011, my lord. And they also filed a writ petition before this honorable court, my lord, 16219 of 2011 and 16220 of 2011, my lord, on the ground that section 4 and 6 of the land acquisition had lapsed in view of section 11A of the Act. Then they, then, my lord, that writ application in 2013, my lord, 2012, my lord, award was passed. Then in 2013, my lord, this they started constructing their petrol pump, my lord. Then after coming to know of that, I inquired and found that there is a notification on section 48 denotifying the land without giving me an opportunity of heard, and that is why I filed. That is why I have challenged this they said denotification in this retribution. So where is the question of sympathy when are fully well knowing?
Let's hear. You proceed, Mr. Mohanty. We'll hear it off finally right now.
Right.
My lords, on 24th of August, an affidavit was filed by the petitioner wherein they alleged that there was an obstruction to their entrance to the plant. I have filed a reply there too, as IDCO, who has given the land. I have filed a reply on 27th of August. If your lordship will kindly take that reply.
Yes.
I don't have a copy of that, Mr.
One copy of a senior counsel.
I means my advocate friend who is instructing me.
All copies have been served. Copies have been. My lords, may I place it, my lords?
No, he categorically.
IDCO has filed a reply. BPCL has filed a reply.
Yes, my lords. And in fact, the assertion that there is a blockage to the main gate or their plant is impacted in any manner.
Mr. Mohanty, do you have BPCL's reply? 26 September.
26 September. Now, this month, no?
Yes.
They have not served any copy on us.
Who's for BPCL?
Mr. Acharya.
Senior counsel, Mr. Acharya appears here.
Have you served Mr. Mohanty?
No.
Or, in fact, even Mr. Narsingh has to be served?
No, I have a copy of it here.
You have a copy. All right. You have IDCO's copy also?
Yes, your lordship.
Mr. Mohanty, only you don't have copies of IDCO and this?
Nice. Both the copies
All right. Copies of the affidavit dated 26th August 2021. Filed by IDCO and 26 September 2021 filed by BPCL. We served on Mr. Ashok Mohanty, learned senior counsel for the. Sorry, Mr. Jagdish. All right. Learned counsel for the petitioner within 3 working days. 11th and 17th November. 17 now.
I can only pray.
We say it is made clear that the matter will be finally heard on that date.
Yes.
My lord, in the last connected matter, I am for the petitioner, my lord. An affidavit has been filed by the land acquisition officer, my lord. I have not been served with that copy, my lord.
In the case of Mr. Bagh, my lord, in the case of Mr. Bagh, I am appearing for the opposite party. He has served me a writ application just 10 days back because your lordship directed. So I will file an objection also within a period of 1 week. Your lordship may call it on that date so that I can also, the pleading will be completed.
My lord, may I be permitted to give a response to that map he has filed before the puja vacation so that he will not be in a disadvantaged position?
All right. You say in writ petition 16220 of 2011, Mr. Rautre appearing on behalf of opposite party number?
Part number 4. Virasti, opposite partner. Sorry.
Must be 2.
Yes, private. But industry, Virasti. The copy they
States that he'll be filing his reply within 10 days.
My.
Rejoinder if any before the next date. And then list along with on the same date. 17th. It is made clear the matters will be finally heard on 17th. And no further adjournments will be granted. Gratefully.
My lord, my writ petition, last writ petition is 19909 of 2013. There an additional affidavit is filed by the land acquisition officer. Let them be directed to serve a copy on me, my lord.
All right. In 19909 of 2013, copy of the affidavit filed by the land acquisition officer be served on Mr. Bagh, counsel to petitioner. within 3 working days.
Let the interim order continue.
All right, interim orders to continue.
Obliged.
May I have my lord stand up? My lord, the maps to which my learned senior is referring to, because they're big maps, I have given it in 2 envelopes, my lord, for the bench in 2 sets, your lord.
All right.
Great. All right.
My lord, I am appearing for the state in all the writ petitions.
All right. All right. Mr. Mohanty nods.
Item number 32.
Your Lordship, may I pray that this matter may be taken up immediately after the Puja vacation? I'm a little inconvenienced today.
All right.
32 years.
States the reason some
After 3 years,
difficulty to-
I have mentioned this matter to come up, Your Lordship.
It's all right. It's all right. It will be finally disposed of. Because there are 26 other
7
matters.
writ petitions are stayed on this judgment, Your Lordship.
Oh, I see.
Only because of the stay on this.
For appreciation of my lords.
All right. Listen, 24th November. All right.
24th.
Item number 33.
Can you pray for a short adjournment, my lord? Because of illness, I could not prepare the written note of submission. Given some time, I will be able to file that.
All right.
The pleadings are complete. We're fine.
All right. Counsel for the parties are permitted to file their written note of submissions within 4 weeks. List after 4 weeks. Right.
Item 34.
Item 34, my lord, on behalf of Mr. D.K. Mahapatra, my lord, kindly taken up next week, my lord. Mr. Mahapatra is ill, my lord.
All right. Mr. Mahapatra appearing for the petitioner stated to be unwell. List after 12 weeks.
Appearance of union have been noted.
All right.
All 4-5 cases.
Yes. Yes.
4 cases.
Yes.
Item number 35.
34. Oh, 35. Sorry. 35. Yes.
Not 35, there is a noting is at 2 p.m. I think therefore they are not there.
All right. 2 p.m. 2 p.m.
Item number 36.
I am
for the petition, my lord.
I am appearing for the opposite party millers. I prefer to wish to file counter millers in this case.
All right. Mr. Devraj Mohanty appearing for MCL seeks and has granted 4 weeks to file reply. Joined within 4 weeks thereafter. List after 8 weeks.
Item number 37.
Same thing. Oh,
7, my lord. I am for the petitioner, my lord.
Yes.
That the pleadings are completed, my lord.
Yes.
Already filed my counter millers in this case. They have to file rejoinder or something.
Rejoinder I have filed.
Rejoinder has been filed.
Yes.
My lord, here I have paid. I am a land loser, and my land has been acquired under this CAB Coal Bearing Act, my lord. And I have paid only for benefit under the rehabilitation scheme, my lord. That which they have denied, my lord.
No, you are right. They're denying that you are in the vote, even the voter list.
Yeah, my lord, but I have purchased a land, my lord. I have constructed a house. They have paid me the compensation for my land, my lord. But now they are saying that I am not a resident of that particular village. I have purchased a land, my lord. That is, they are not denying. I have construction of my house also not denying. But I have in my gender, my lord, I have filed the residential certificate issued by the Tahsildar concerned, my lord. That is page
When did you buy the land?
Page 182 of the.
No, did you start living there is the question. If you're not there in the voter list, then what happens?
My lord, my voter list I also filed in page semester 11 at page 183. Part of the voter list. That is my name is the voter, my lord. That is there in page 183. I have purchased the land in the year 1996. I have constructed a house by converting the agricultural land to non-agricultural land, my lord. Which I have paid the
when you converted, when did you make conversion?
Conversion in sometime in the 2007, my lord.
After 4-1 notification.
Yes, my lord. That is admitted, my lord. That is admitted. But the government is.
If you purchase it after the 4-1, then it has no validity, please.
Yes, my lord. I do agree with that, my lord. But the government has allowed my application in the year 2007, my lord. I have applied it immediately.
There is no estoppel against law.
Yes, my lord. That's true, my lord. That's true. But my lord, that only ground that I am not a resident of that particular village.
No. Even your purchase is after the 4-1 notification.
I have not. I have purchased in the year 1996, much before.
Conversion.
From cultivable land to homestead land.
Oh, I see.
Only the conversion part is disputed, my lord. I have purchased in the year 1996, much before the notification.
No, at the time of purchase, it was an agricultural land.
Yes, my lord. Yes, my lord.
It was not a homestead land till you made the conversion.
Yes, my lord.
And the conversion was after 4-1 notification.
Yes, my admitted, my lord.
That means on the date of 4-1 notification, you are not a resident.
No, my lord.
You do not have the house. How could you say?
My
because
lord,
you made conversion, if you made the land converted to homestead after 4-1 notification, then on the date of 4-1 notification, you are not a homestead.
Correct.
You are not a resident of that area.
But, I am a land housee, my lord. I am a land housee. My land has been acquired.
Maybe a land housee, but you are not a displaced person. That is the issue. The issue is whether you are coming within the definition of displaced person.
Yes, my lord.
Yes.
Page 34, my lord. Page 34 of the brief, I have given the 2006.
What is the material with you to show that you are a resident of that area?
My
Do you
lord,
have any residential certificate?
Yes, my lord. Residential certificate. I have given the residential certificate.
Which annexure?
Annexure 10, my lord. Page,
Which year? Which year is that?
Under affidavit.
Which year is that?
2020.
Sure.
That won't help you, sir.
And also the
2020 certificate will certainly not help you. We are now on the date of acquisition.
And also, my lord, the voter list at page of annexure 11, my lord, which clearly shows that I am a voter.
The voter list is of the year 2017.
Yes, my lord, 2017.
Again, none of this helps you, sir. We are now on the date of acquisition, right? 4-1 notification.
On the date of acquisition, I have my land, my lord.
No,
I have my land.
I think you're missing the point, Mr. Guru. Your conversion into homestead happened after the 4-1.
Yes, my lord.
Which means you are not living on the land. If you're not living on the land, then you're not entitled to this R&R. You've got compensation already. You are not an oustee, please. You're not an oustee.
I am an oustee, my lord. My land has been.
Anyway, everybody who loses land will claim to be an oustee, but that's not the point.
Okay, my lord.
You are getting compensation for land.
Yes, my lord.
If you were living on it, then you would be an oustee. You are not living on it.
Yes, my lord. I was living on the land by constructing a house.
No.
By the time they pay my...
You have not produced material to satisfy us about that.
I will file an additional affidavit.
No, enough. We can't go on like this.
My lord,
counter rejoinder all over. Counter rejoinder is all over.
My lord, let me submit, my lord. In the 12th RPDC meeting, the government has taken a stand, my lord, and directed the NCL authority to extend all the benefits of RR
yes,
policy.
Provided you are displaced.
Yes, ma'am. They have said that the person who have land in the village, they have to be given this benefit of the RR policy, my lord.
That's right. They have to establish they were oustees and then they will get benefit.
Yes, ma'am. That is the government producer latest directive, my lord.
Anyway, all right. We've heard you. Now, dismiss. We'll pass the detailed order. All right.
Item number 38.
38 no, I have handed over the
Next
status report for a lordship's kind perusal.
Let's see the status report.
May I pray for
That is
next
not the
One
case
minute,
of
please,
allotment.
see the status report. This is a writ petition criminal. Are you not interested in seeing the status report? There is no status report, he says.
Yes, Master, I have sent it by mail. By mail, I have sent. Maybe Pastor, but I am sending it to the court directly.
All right, pass over. 39.
For hearing, item number 39.
May I please, my lords? The question involved in this case is, which I have set out at page 33 and 34 of this revision application, whether the petitioner runs hotel and is as such entitled to exemption under entry 30 quadri F of the exemption list, or is ineligible as guest house and restaurant members. This question is answered by your lordship by recent judgment in the case of this petitioner. That by judgment dated 7/9/21, which I have given to your lordship.
Correct.
There are two questions your lordship answered. Your lordship may not attend to second question. That is not relevant here. That is first point, whether IMFL and cold drinks. Your lordship is confined to first issue, which your lordship decide my favor. And para 20 of the judgment, your lordship are referred to three tribunal judgments, which also answers in favor of this petition, this issue.
All right.
I have given a copy, to your lordship.
All right.
My lord, may I submit, my lord?
Yes.
Here, all are same as my learned senior has pointed out. But the only difference is if my lord will turn to page 40, the eligibility certificate of sales tax exemption. Annexure 3, page 40, my lord.
Yes.
My lord may come to 41, the next page.
Yes.
Clause number 4. This certificate is for the year 1792 to 31/3/93. So the present period of assessment is 90 to 93. So unlike that other case, here the exemption is to this period because this is the first year of his getting the exemption. So the period starts from 1792. So from 31st to 1/4/1992 to 1/7/1992. Was not having the sales tax exemption. So this period, my lord, is to be
3 months.
Yes, my lord.
All right.
This will abide as per the eligibility certificate.
Right. You say there are two questions that were framed by this court in the present revision petition that arises from an order dated 21st May 2007, passed by the Orissa Sales Tax Tribunal in essay number 30/2001 and CA number 108/2001, filed by the state against the petitioner SSC. The above appeal was filed by the state against an order dated 20th November 1985 of the Assistant Commissioner of Sales Tax, ACST, Cuttack. Reducing the extra demand of rupees 454,857 raised by the Sales Tax Officer, Cuttack, in an assessment order under Section 12(4) of the Orissa Sales Tax Act 1947 (OST Act) for the year 1996-97. Rupees 5551 paragraph. This set out those two questions. As regards the above two questions, this court has, in a recent judgment dated 7 September 2021, in ST REV number 20 of 2027, Akbari Continental Private Limited, the State of Orissa, concerning the same SSC for the year 1999-2000, answered the similar questions that arose in favor of the SSC. In other words, as held at the above judgment, question number 1 is answered in favor of the SSC by holding that the circumstances of the case in the circumstances of the case, the ineligibility attaching to a restaurant does not affect the petitioner's claim of sales tax exemptions that is applicable to a single course hotel, unquote. As regards the second question, it is again answered in favor of the SSC by holding that the tribunal was not justified in rejecting the claim of sales tax exemption by the petitioner under entry 30 triple F of the tax free schedule, unquote. Question mark. Paragraph, Mr. Padi, learned additional standing counsel, refers to the sales tax exemption certificate, eligibility certificate at annexure 3 and points out that the eligibility period is from 1st July 1992 to 31st August 1993.
March,
March 1993. And that the above exemption would not be available for the period 1st April 1992 to 1st July 1992. Mr. Sahu does not dispute the above proposition. Paragraph. The demands will now be reworked on the above basis in accordance with law. The revision is disposed of.
May I prefer re-looking at the facts? Probably at the time of dictation, Millards, I found the demand in this case, as per assessment order, is not 1 lakh some odd. At page 42, 1,59,652. I lost before both in first appeal and second appeal, and this revision before Lordship is as my instance, Millards. Probably there is some facts, something else is Lordship. The demand raised at page 42 assessment order is 1,59,652. Period involved 92-93. Whereas petition was unsuccessful both in first appeal and tribunal, and at my instance, revision is filed.
That's right. No, so the appeal, no, but at page 145, what is that order of the tribunal is in an appeal filed with the state?
No, that is
That's different, my lord. That's for a different period.
That is different period.
Oh,
Here,
so
order, yes, that is the
Okay.
sum. Yes, order input is 64 below. Page 64.
Right, right. So
Yes.
that was arising out of, you say, order dated 24th January 2002 of the Sales Tax Tribunal in essay number 3563, 95-96, filed by the present petitioner for the year 92-93. Right. All right. All right.
And there are 3 questions of formulated before your lordship in this revision. At page 30.
No, but when they admitted it, you see the order dated 21st August 2007.
My lordship, sir.
Only 2 questions were framed.
Right.
Right. All right.
Item number 40.
number 41, your lordship, Mrs. Shraddha is currently out of station.
Lord. I see. All right. Counsel for the appellant is stated to be in some difficulty today. List after 12 weeks.
I am appearing on the opposite party, my lord.
All right. All right.
I am physically present here, my lord.
Oh.
I am physically present.
All right. Oh, sorry. Yes. For a change. Mr. Sahu was mentioning
Yes,
some.
yes. At 2 o'clock. I will agree.
Item 20 minutes. Item 20 minutes.
He agrees. He's agreed.
Yes. Item 20, if your lordship can take it up, there's some clarification only requires.
It will be disposed of, my lord.
He's agreed to the clarification.
Minus, yes. Your lordship will say that annexure 11 may be set at rest in view of the order passed by your lordship minutes.
All right. Annexure 11 is set at rest in view of the order passed by this court. All right.
In item 38 plus, I have passed on the instructions.
38.
38 plus.
Is it there?
Case of allotment.
All right. Mr. Katkia places the report dated 29 September 2021 of the IIC Pattamundai PS, Kendrapada.
Item number 35.
Tripathi was supposed to be there, Milad, along with Mr. Sangal.
Yeah. Lord, I am here.
My lord, Mr. Tripathi has already come. He will appear physically.
All right. We'll just then do the other matters and come back to this. All right.
Pass over item number 7.
16, I think.
7 and then 16.
Sorry.
Yeah, please, lordship, in this case, lordship, my lord, I have left my, sorry, my lord, I have left my file in my chamber, my lord.
Okay.
My difficulties is, first I mentioned by virtual, but I think.
Sorry.
File is not with me, I have left my chamber, lordship, that's why. It is, my lord, this is committed rape in the 5 years old, my lord. My victim is 5 years, my lord.
I know that judgment you were to produce. You were going to produce a judgment.
Come next week, lordship. Any date, lordship, I will put. Judgment I have given, my lord.
But file you have kept, is it? All right. The question of bail doesn't arise, no?
No. Here is lordship.
Has left his file.
I know. I'm saying bail.
My lord, I have also produced a judgment. My lord, I have also submitted a judgment.
Are you pressing this bail now?
Your lordship,
it's better you do not press the bail.
Trial court committed life imprisonment, my lord. But so far similar puttings that Honorable High Court is reduced to 10 years lordships. Similar putting lordship.
My lord, I have also placed a judgment before the lordships, the recent judgment of Honorable Justice Chandrachud and Justice M.R. Shah, my lord, where this 376(1) has been, after the amendment, my lord.
Yes.
They have discussed that, my lord. If your lordship, I can take your lordship to that.
Anyway, he'll also have to go through it. What? Give us a citation.
I have placed it before a lordship. I have given it. It's 2021 SSC online Supreme Court 343, my lords. I have given the hard copies, my lord.
Yes, yes.
Because the proviso itself says.
Patan Jamal Wali. Have you seen this judgment? Just give him a copy of this judgment.
After the amendment of the 2008 amendment, it's very clear, my lord, that minor has been raped, the punishment cannot be
Diluted, no?
Yeah,
Correct, correct. So we just give him this judgment. So you say there's no question of, you say having 240 of 2021, having examined this application, the court is not inclined to entertain the prayer for bail at this stage. In the main appeal, you say, learned counsel for the appellant has placed reliance on two judgments in Bavo alias Manubai Ambalal Thakur versus State of Gujarat, 2012 Criminal Law Journal 1573, and Pramod Mahato versus State of Bihar, AR 1989 SC 1475, and submitted that since the appellant has already undergone over 10 years of custody, the sentence may be reduced to the period already undergone. On the other hand, learned counsel for the state has placed reliance on the recent judgment of the Supreme Court in Patan Jamal Wali versus State of Andhra Pradesh, 2021 SEC Online SC 343. List for hearing on 22nd December. All right.
Item number 8.
I think
Is it matter?
I appointed some legal counsel.
One blow on the left neck as a lordship was appreciating.
No, that was the other one. None appears for the appellant despite a passover. Nevertheless, this application, you say 671 of 2020, this application is allowed, considering that the petitioner is in, appellant is in custody since 10 July 2010. The appeal is set down for an early hearing. The main appeal, you say, set down for early hearing on 20th December 20.
Item number 16.
Lords, I have seen the judgment produced by in the earlier case. Land acquisition. But in this present case, Lord, they have already filed their objection even after filing of this writ petition. I have taken the instruction now.
So that can be disposed of.
In fact, I was challenging the very initiation of the proceeding and the report itself, the SIA report itself. And thereafter, in spite of the fact that there has been no meeting, no Gram Sabha at all, the section 11 notification has been made. That was under challenge, in fact. If that can be considered by because the scope of section 15, I think, let me see whether
in that case, we'll just issue notice then.
In that case, I am appearing for the opposition of 4. Section 15C. All these grievances can be taken care of under section 15. Kindly take up section 15. 15 says that there are 3 incidents on which he can file objection. Number 1, the area and suitability of land proposed to be acquired. Number 2, offered for public purpose. Number 3, the finding of the social impact assessment report. All 3 can be taken care of by the collector, with whom he has filed the objection. All the petitions are filed, and all the entire prayer of the petition can be taken care of by the collector.
You can renew your prayer. Suppose the collector's order is against you, you renew your prayer.
With that observation, without recording my withdrawal, what my prayer is like recording without recording my withdrawal, direct.
Yes. Mr. Manti, on instructions appearing for the petitioners, states that they have already filed their objections
on 3/9
under section
2021.
15 bracket 1 of the 2013 Act on
3/9/2021.
3rd September 2021. Is it delayed or within time?
No, within time.
Within time.
Bracket within time. Full stop. In that view of the matter, the petitioners are permitted to urge in the said objections all the points raised in the present petition, which will then be considered by the appropriate authority, and a reasoned order will be passed disposing of those objections, after hearing the petitioners, not later than 10th January 2022. A copy of the order will be made available to the petitioners not later than 17 January 2022. Paragraph. If agreed by those orders, it will be open to the petitioners to seek appropriate remedies.
After and then after this order, only my prayer is
In this case, my name may get reflected. My name may be reflected in the order.
I'm sorry?
My name may be reflected in the
Yes,
order.
yes, yes. Mr. Sarangi for.
My parent may kindly observe that after submission of the report by under section 15(1), I can approach the lordship chapters.
Not us. We just say appropriate reliefs. You can see.
That is the.
We don't have to spell out everything, sir.
No,
there are some things that you should.
That's true. The language is its final. The language is its final.
Once we say in accordance with law, we don't have to actually spell out the entire scheme of.
Definitely.
Item number 17.
None appears for the petitioner despite a password in the interest of justice list on 9th November.
Item number 19.
None appears for the petitioner despite a password. In the interest of justice list after removal of all defects.
Item number 35.
See, in the interest of justice list on same thing, 9th November, defects be removed by then. All right. Sorry. Yes, Mr. Tripathi.
My lord, I was answering my lord's question the other day. That how can you demonstrate that these appellants were conscious of the fact that despite repeal of 1994, they have indeed granted to others, and on what materials that you can place on record to indicate that they have done despite the repeal. But I have already given some of the orders which are passed despite the repeal of 1994.
Right.
But that apart, please, my lord, take my counter affidavit. My lord, my counter affidavit, page 30. Let us see that. Page 30.
Counter referred page.
Page 30. Proceedings of the meeting held on 1st of May 2013.
Right. That's at 140. Page 140. Do the page.
Counter is of 9th of August 2021.
Yes.
And page 30, the meeting of the committee held on so and so on 1st of May. This is extremely important document for the reason that this proceeding which is recorded by the additional secretary when he makes an endorsement to the principal secretary. In the chamber of additional secretary higher education, Director Malad is also present, had made detailed study of the overall picture position of the two institutions. He indicated that the specific suggestion as to how the two colleges, that is so and so, will be handed over to Government of Orissa Department of Higher Education. After discussion, it was decided to bring the two colleges into the GIA fold by extending the provisions of 1994 grant in aid to cover these two colleges. But there was a statutory constraint to extend the benefit of GIA to the colleges managed by the public sector undertakings. Hence, it is suggested by the director that OSPC would first hand over the colleges to the district magistrate to be managed by the private educational agency. The said agency, after taking over the management, shall apply to the Director Higher Education for grant in aid. Government in the Department of Higher Education will take a decision to declare these two colleges aided under GIA Rule 1994 and authorize the Director to undertake the verification of the records of the college for approval of post and sanction of GIA. Now, this 1st of May 2013, my lords.
So you think it is a conscious decision to extend the 1994 GIA?
1994 was expressly, my lord, mooted,
right.
And what was approved by the principal secretary, I'll show, my lord, now the documents, is 1994, contrary to what Learning SG, my lord, has been submitting, and all wrong submissions. Please see, my lord, down below who the signatories are. In the first, my lord would see DP Behra IS, who is the additional secretary to government. It is this DP Behra who makes, my lord, now a note to the principal secretary on 13th of August 2013. Can he, my lord, say differently? Having recorded here to the minutes of the meeting that what was to be extended to these colleges is 1994 and none else, he couldn't have, my lord, conceptualized something else, that is 2004. That's what Learning SG, my lord, is submitting for the last 3 occasions. Please see, my lord, how the proceedings develop thereafter. My lord, kindly see page 32, is the report of the colleges. Then, my lord, in consequence of the decision of 1st May 2013, there are 4 things which ensued. First, these colleges were under the control of OHPC. The statutory constraint which my learned Advocate General, my lord, is saying by placing reference to section 7C, that so long as it is under the public sector undertaking, the grant in aid cannot be extended, is sought to be taken care of by these minutes of the meeting when they say that because it is under a public sector undertaking, it needs to be divested from the public sector. It will have to be put at the disposal of the government. And before the government, my lord, is taking over, the first step would have to be that they will have to be there in the private management. Now, in pursuance whereof these decisions, these colleges, my lord, were indeed given to the private management, put at the disposal of the district collector. OSPC was divested of the responsibility, and my lord, the salary that I was getting 30,000 per month has been reduced to 11,000 per month. That's the repercussion which my lord was kind enough to ask the question the other day. That what happened, what is the difference between 2004 and 1994? Learning SG, my lord, conveniently remains mum on this subject. Because these steps were taken in furtherance of the decision that it has to be 1994, 4 things happened. I asked the question to myself, you took these decisions for what? Why did you divest the control of OSPC? Now that's question 1. Question number 2, these are the minutes of the decisions of the government, high-powered committee. 2, the 30,000 salary which these lecturers were getting is reduced to 11,000. The leave encashment and other statutory benefits which were otherwise made available has been practically reduced to be zero. And today what is given to me, my lord, is 11,000 because of this erroneous decision. Please see, my lord, the further documents which would fortify that it is 1994 throughout that the government was aware of, not just by the day that the London single judge took the decision, but even post the single judge decision, there are documents to indicate that government had no difficulty to understand that what was sought to be granted to these colleges is 1994 and none else. Well, this appeal appears to be to satisfy somebody's ego. The realization with regard to quibbling over that word applicable has come only after 7 years when the contempt court was kind enough to summon the principal secretary. Till then, not even an application was filed. Therefore, my lord was right on the first day when the interim was granted against me that Mr. Advocate General, why didn't you move an application at least for a clarification if there was some ambiguity in your mind? But I would indicate now from these documents which have been filed on the record that even after the decision recorded by the London single judge while disposing of the writ petition on 16th of April 2015, there are documents which are written by none other than the principal secretary, who is the appellant before my lord, that the decision taken to these colleges is 1994. It's a complete abuse of the process of law, and I would pray, my lord, to dismiss this appeal with exemplary cause. Please see, my lord, how these documents develop thereafter. Page 32, my lord, the report. OSPC, my lord, is giving the report at page 33. My lord, somewhere in the middle, this college has submitted application for availing GIA at the relevant point of time under the provisions of GIA Order 1994. But no government notification declaring college as aided one has been issued due to reason that the college is being managed by public sector undertaking and not eligible. This is the argument of London AG consistently. Then my Indravati Mahavidyalaya is indicated. The last para, the college got government concurrence from the session in science and arts stream with following subjects. Subjects have been indicated. Then the next college is written, and at paragraph 3, both the colleges, that is Indravati, Jayapatna and Indravati Project College, are financed by OHPC Limited and at present both the institutions are having good infrastructure, while Indravati Mahavidyalaya, Jayapatna has its own land in its name. Indravati Project College, Kathiguda, has no land of its own. It's functioning on the land of irrigation department allotted for the project. Question of taking over the college by the government may create resentment, as there are other old institutions with better infrastructure facilities. So far as inclusion of these institutions under GIA fold is concerned, subsection 6 of section 7C envisages that educational institutions established or managed by the public sector undertaking shall not be eligible for GIA under this act. In order to bring these institutions under the fold of GIA, it would be badly necessary on the part of the public sector undertaking to withdraw their control. This step, my lord, has been done thereafter over the institutions and allow the colleges to be managed by private management. If the same is complied with, the institutions shall come under the private management to meet with the provisions of the Act for inclusion of these institutions under the fold of GIA. If it is agreed, the OSPC authority are requested to transfer movable and immovable property under the possession of the institutions in the name of the said institution with the funds available in the account of the college. Inclusion of these institutions under the GIA fold shall be considered for releasing grant to the teaching and non-teaching staff as per the yardstick. Ways and means to sanction the grant and quantum shall be decided, keeping in view the fiscal position of the state exchequer and in same footing as the contemporary institutions of the state will avail grant from the government. Government will accord their approval to the proposal for inclusion of the colleges in the GIA fold under GIA Order 1994 in accordance with the provisions made for left out colleges. Then there are GIA equivalent to so and so. Please see who is he is the sanctioning authority as per the Act, director, recommending authority. And after this, kindly see, my lord, how.
What is the date of this?
Director's report. That this is.
Some date is there under their signature, it's not legible. No date.
Well, this would be 13th of May 2013.
My learned friend could be right, Because if your lordship sees page 76, this report has been sent to government.
And
76
after,
of the paper book.
then, my lords, the next document would be at page 39. My lord, somewhere in the last, towards the last, in order to overcome the above difficulties, this is, my lord, that DP Behra, who was a signatory to the minutes of the meeting.
Right.
Meeting of the committee was held on 1st of May. My lord, this is conveniently ignored by London AG, the import of this meeting, wherein additional secretary, director of higher education, OSPs were present. Proceedings of the meeting dated so and so. It was decided to bring the two colleges under GIA fold under the relevant provisions of the GIA order. There was a statutory constraint to extend the benefit of the GIA to the colleges managed by public sector undertaking. Hence, it was suggested that OSPC would first hand over the colleges to the district magistrate.
So this is where the word relevant.
Yes, but therefore, my lord, what the additional secretary is writing here.
That's the point.
That's right. Yes, yes, that's exactly the point. My lord, the additional secretary is writing what was written there, verbatim, he is reproducing this paragraph. The same additional secretary who in the minutes of the meeting suggested it is 1994 is saying here the same thing, except one word, my lord, which is using here, relevant GIA. He is not making a departure from 1994. He could have comfortably said here that it is 2004. He is not saying so. And my lord, what is approved by the principal secretary next down below, that is 13th of August 2013, is notes above may kindly be perused, not just the additional secretary, but even the report of the director. So before the principal secretary to government, my lord, the report of the government, the director, the note of the additional secretary, the minutes of the meeting which my lord has seen on 1st of May is available. And he is then making a conscious decision that higher education department doesn't have any objection to take over the colleges which would come under the granting and fold. Now, therefore, once a minutes of the meeting that has crystallized way back in 2013, in which there are 4 things that took place. One, these colleges, my lord, were given to the private management. Before that, it was put at the disposal of the district collector. The statutory constraint of OSPC was taken away. And in terms of the salary, my lord, these people were getting 30,000 salary per month. That was reduced to 13,000. Now, in furtherance of the decision taken on 1st of May, these steps were taken. And please see, after my lord, 13th of August 2013, how the government has behaved itself. Please see, my lord, page 44. This is, my lord, post London single judge order. In inviting a reference to the cited subject, I am directed to request you to submit necessary form application in triplicate with all supporting documents as per the Orissa Government Order 1994. Please see, my lord, the date, 9th of July 2015. So director is writing and endorsing it to the additional secretary, appellant before my lords. At no stage did the principal secretary, who is the appellant before my lords, disown these contents of this letter. That if what was decided in 2013, according to the appellants, is 2004, then nothing prevented this additional secretary or the appellants to disown the contents. Why are you writing 1994? When did we take a decision of granting 1994? Please see next document again, 6th of August 2015.
Yes.
It is written by the Department of Higher Education, the same appellant before my lords. And the copy is marked to the principal secretary to Government Higher Education. So throughout, my lord, they have understood it to be case of 1994. Please see, my lord, 6th of August 2015. In inviting a reference to DO number, the Department of Higher Education is writing to the Principal Secretary, Department of Energy. On the above noted subject, I am directed to say that pursuant to the order of the High Court, passed in the aforesaid case, Director of Higher Education has already been requested by this department letter to take appropriate action as regards notification of Indravati College and so as an aided educational institution as per the provisions of OE Act 1969. Subsequently, in response to this department letter referred to, the Director of Higher Education has requested the President Secretary Governing Body of the said two colleges to submit for bay as per provisions of Grant in Aid 1994 for consideration of their claim. Page 45.
Yes, yes, we're on that only.
The very appellant before my lords is writing this. And please see my lord, next page, page 46. And kindly note, my lord, these are all documents post Lord single just or disposal of the writ order.
No, but Mr. Tripathi, were these people, when they're writing all this, were they conscious that there are already, there's one more GIA which has come, which has replaced this? Are they conscious or they're still proceeding as if there's only one GIA?
But if they were not conscious, despite the repeal of 1994, they have been granting it to, I have already placed 6 orders, which London AG Mallard has been asked to respond to.
No, that all the more makes me ask this question. That's why.
That's right, Bharat.
When did they wake up to the fact that there is no longer GIA in 1994?
Bharat, they wake up, even till date, they don't wake up. With this repeal business means nothing to the state government. Because they have been granting it to many, even in 2020 after Anup Kumar Sanpati judgment.
So I think the point you're making is this. Even in August 2013, which is page 40 of your counter affidavit.
Page 40. Yes.
That is 13th August 2013, correct?
Yes.
Which used the word relevant. In 2013 August, they used the word relevant. One minute, let me just say what I want to say and then you can respond.
Yes.
When they use the word relevant, the Advocate General wants us to understand that at that point in time, somehow they realized that we are no longer dealing with 94, we are dealing with the later GIA, and therefore they use the word relevant. This is the argument.
That's right.
But if that is correct, then how do they continue referring to GIA 1994 even thereafter?
Therefore, Advocate General is entirely wrong in his submission.
1 minute, please. You obviously jumped to that conclusion. I'm still on the question only.
The fact that the subsequent documents would indicate the
when there is a flighted delivery, I know you'll rush out.
But no, I'm here. Well, the fact that post disposal of the order by the London single judge while dealing with the writ petition.
No, I'm still on the question. So on 6th August 2015, which is 2 years later,
yes,
when the additional secretary of the government writes to the principal secretary, this is what you're trying to argue, I suppose.
Yes.
He's still referring to the GIA of 1994. So probably you're just arguing that they were still only dealing with, or they were fully conscious that they were only dealing with GIA 94, despite the fact that there's another GIA in the meanwhile.
Quite right, Bharat. They're fully conscious of the fact that despite repeal of 1994, what was sought to be granted to these two colleges by the decision of 13th of August 2013.
But legally,
is
now tell me
1994.
legally. Yeah, okay. We keep that aside. There's no estoppel against law.
Yes.
Legally, tell me, is it permissible for a group of bureaucrats to say, although GIA 1994 is repealed, we will still grant the benefit of that GIA? Is it legally permissible, you tell me?
Yes, but I'm dealing with that legal point. My respectful submission before my lords would be, when London single judge was dealing with the writ petition, this canvas which is raised for the first time in the writ appeal, that it was repealed, it couldn't have been granted, was not there before the London single judge.
That is all, those are all procedural technical points. I'm the core point now.
Well, I'm trying to develop my argument. Just bear with me for a minute.
All right.
Now, my lord, therefore, in as much as the London contempt judge, my lord, cannot traverse beyond what the order originally was contained, and my lords would find fault with that order, my respectful submission is that he's only reiterating the order in the contempt jurisdiction. He is neither supplementing the order. All that he meant while disposing the writ petition was that it is 1994. When London AG, my lord, has argued before my lords that the direction to me was to take a further decision, that submission appears to be erroneous because the language used by London single judge is very conscious. that you are directed to take a follow-up action in terms of the decision. The word is follow-up. That decision has become final. The order of learned single judge has not been impeached, except, my lord, it was attempted to be impeached and it was withdrawn before my lords. Now, my lord, if the decision was final, the law is merely because a subsequent decision or some other development has taken place. My lord, I am referring to Anup Senapati. That cannot invalidate the decision which is already presented earlier, determining the rights inter se. My lord, that's one. And second, if you would never took that plea before the learned single judge with regard to the repeal of 1994, and yet you persuaded the learned single judge to take a decision in the manner in which it was taken, you can't today in 2021 fall back upon the repeal of 1994 and say that I want to wriggle out the effect of 1994 by saying that it has been repealed. Now, that submission, my respectful submission before my lord would be, possibly would be not tenable. My lord, I would
now you have to still answer the question.
Yes.
So today it is being argued before this court. There's a repeal of 1994 by the GIA of 2008, is it?
2004.
2004, my lords.
2004.
2004. Are we supposed to say, no, you never argued it before the single judge, so we will not allow you to argue? This is what you are arguing.
Well, that would amount to
I'm just trying to understand your submission, sir.
Yes.
When I'm asking you a neat legal question, you're saying, no, you never raised this point earlier. We will not allow you to raise it now. You never told this to the learned single judge. You can't argue it now. You allowed that decision to become final. Now you can't, in the contempt stage, come and say this. Now, all this, is it an answer to the question whether reliance and effect can be given to a repealed scheme? Is it an answer to that question? How do you revive something repealed?
My respectful submission would be, which I have submitted just now, that having not told the learned single judge with regard to 1994, and you invited decision in
you have to logically answer this.
Yes.
You take this circumstance, because you are now stuck with this whole scenario. You step back. You have to test the proposition, correct? Let's take some other thing, some other scenario. A repeal law is there. A new law is here. Everybody has gone and told even the single judge that we are only going to do it in the repeal law. The single judge grants relief in terms of the repeal law. In the appeal stage, it is said, listen, there is this law itself is repealed, it's been replaced by this other law. Is the division bench supposed to say, forget the new law, since everybody went by the repeal law, we will go on the presumption that the repeal law is what should apply? Is that a legal answer?
Well, obviously, I can't countenance that submission, well, in that way. The fact that
you have to test a proposition. I'm just saying, what is
the fact that 1994 stood repealed in 2004 is something which I possibly cannot say to the contrary.
So, in fact, we have all this per curiam, sub silentio, these documents, these doctrines got developed, sub silentio or per inquirium. They were developed only because genuine mistakes were made by courts and lawyers by not noticing a binding judgment or relying on a judgment that's been overruled by a larger judgment, not noticing a statute at all. These doctrines developed because people went on certain presumptions. And we deliver judgments only on the basis of what is placed before us. Today, let us say in the morning, we both have delivered a judgment without noticing a binding judgment of the Supreme Court to the contrary. We would have made a mistake, but we were not told by any of the lawyers. So we went on that presumption, correct? I'm just saying these doctrines were developed because of these mistakes happening. It may not be an answer to say, listen, why you did not point out this to the single judge, you should not be allowed to point it out to the division judge. That can't be the answer.
Matter of pointing out to my lords in the appellate jurisdiction is one thing, but in persuading my lords to do something which the learned single judge didn't do, particularly when the judgment of the single judge, my lord, became final, would mean that my lords are interfering in an indirect manner the decision of the London single judge.
No, what do we do? The whole result of all of this, what you are asking is, result is that we are going to give effect to something repealed.
No, but if I can demonstrate.
It is a quandary, isn't it? Is it a quandary? If we accept the single judge's judgment, then we will be giving effect to something repealed.
Not if Lordship will permit, I may be able to answer that question.
No. Naturally, you will be able to, of course, Mr. Sangal, you have to wait for a minute.
Yes. There's something I may be able to answer.
But I would reiterate my submissions. I understand the difficulty, but it's not as if that I'm not cognizant of that. But I have shown the documents right from the day.
No, you're right. I'm presuming all of this to be correct. See, we're not doubting this at all. People went on a certain presumption. For a long time, I think there are nomenclature of Indian Lunacy Act. I remember that because I was involved as a lawyer in this bringing into effect the new Mental Health Act. This is one of those statutes. For 7 years, they did not actually notify the act. In 1994, one fine day it was notified. Documents of the government were still referring to the Lunacy Act of 1912 for a long time. When we went in contempt back to the Supreme Court, looked at Assam, looked at West Bengal, all the documents, forms, everything was still referring to the Lunacy Act. They were all proceeding on daily business, including magistrates passing orders, institutions running all on the basis of the Lunacy Act. They pretended as if there was no new act. It can happen. I'm just saying it can actually genuinely happen. We're not going to say that this was deliberately done or not, but it could be a genuine mistake of not noticing that there is something else that has happened.
But the fact that it cannot be genuine a mistake is evidence from the documents in which my lord has seen that not just before 13th of August 2013, even after the London single judge giving a direction by exercising the jurisdiction, there are documents which...
See, the only way, Mr. Tripathi, the only way to show that the new GIA was present to their mind and still they went for the old GIA is to show any document where there's a reference to the new GIA.
No, there is no other reference.
See, that's the difficulty here. Let's say somebody brought it to the notice of one of these secretaries. Sir, there is one new GIA. Then in the note he says, yes, there is a new GIA. But since we've gone and committed ourselves, forget the new GIA, let's do only old GIA. And you show me that note. No, you show me that note.
Well, the repeal was done by none other than the appellants themselves.
Whatever, sir. We pass so many judgments on a daily basis. It's impossible. These people probably are signing some 300 files every day.
And in respect of 9 colleges today, which I have filed through an IA.
They've still given the 1994.
1994, as early as in 2020, post Anup Senapati decision of Supreme Court, they have granted. I have passed that order, I have filed that order, my lord, in my counter affidavit. Anup Senapati was rendered in 2019. London single judge decision was way back in my lord in 2015. They waited for about 5. Now, look at the injustice and iniquity that is going to be caused to these people. Forget about my lord for a minute. Kindly brush aside, my lord, if the technicalities are coming in my way. My lords are known for molding the justice. Would it be just and proper for these people, having given them the hope for the last 10 years? OSPC, they were under their control. You divested it. You are giving them 30,000 salary. You reduced it to 11,000 with the hope that one day they would be eligible to get 1994. That's a full cost salary. The 2004, which is now, my lord, promised to be given, would reduce them to 11,000. And the private management was taken away. They put at the disposal of the collector. These are the steps which are taken in furtherance of the decision of 1st of May 2013. Look at the injustice, my lord. Their backbone has been snatched away by these litigations taken by the government. One round in Supreme Court, London single judge contempt this proceeding, and this is not one contempt, 2 contempts. And these are lecturers who are imparting education to the students. I'm sure Lord Neji is not going to deny the fact that the total salary that these people are getting today is 11,000, which was.
We don't know. We haven't heard him on that yet.
That's right, my lord. Which was, my lords were kind enough to ask that question to Lord Neji, that the ramification between 2004 and 1994. As usual, the answer was nothing. It was 30,000 with instructions.
I think, my lord, my share of abuses is over now. I think now we have to make some compromise.
No, but you have given that privilege that I am physically present and you are there in the computer.
Mr. Tripathi, I was unwell today, but I didn't ask for an adjournment because you would come and then shout at the court.
Then, my lord, please see the further documents.
Yes.
This is one, page 46. Again, my lord, 12th August 2015, series of documents. My lord, this is again written by Department of Energy, and kindly see whom it is marked to the appellant, Additional Secretary to Government of Higher Education. In inviting a reference to the subject above, I am directed to enclose a copy received from so along with the required documents as per provisions of the GI Order 1994, so as to consider for the notification of the colleges. Marked again to the appellant. Appellant doesn't choose to disown this document either. In 2015, he could have comfortably said, my lord, the decision that was taken in 2013 was 2004. Did he say so? No. Please see in the next document. 14th of August 2015. This would indicate, which my lords are thinking aloud, can it be shown that these appellants were conscious that despite repeal vigilance, they were still thinking in terms of granting in 1994. But the next document is 14th of August 2015. Director, my lord, the secretary, in furtherance of the decision that was taken earlier, is writing, in inviting your kind attention on the letter and subject cited above, I am submitting herewith Form A application, Kathiguda, with a required documents in triplicate as per the provisions of GI Order 1994 for your kind information and necessary action. And the last document, my lord, is at page 49. This is 28th of October 2015. Again written by the higher education. He is the appellant before my lord. In my lord, the second line from the top, the sub-collector Nabarangpur cum President GB College had submitted for a application on so and so in triplicate, a copy of which is enclosed herewith for reference. The original records of the college were verified in this, and subsequently on so and so, the findings in above verification report is enclosed herewith for reference to the government. The college had received government concurrence and corresponding application in respect of so and so for the academic year. The college being situated in the educational backward district of undivided Koraput as per 1991 census, is otherwise eligible for government notification as per GI Order 1994 for the purpose of extension. The financial application in respect of the present proposal is also enclosed. But this is written by the higher education to the Department of Higher Education themselves. So, yes. They rather are trying to justify the grant of 1994 on the ground that it is situated in a backward area here. But that seems to be the consensus decision.
See, some of those colleges, I don't know about those colleges.
Well, there are colleges in Koraput district.
No. Some colleges may have been taken over earlier.
Yes.
Before 2004. I'm just trying to think. If it was already taken before 2004, when the 2004 GIA had not applied, I think GIA 2004 is prospective.
Yes, prospective.
But in your case, both these OHPC institutions were taken over after 2004.
In 2013, I think.
Yes.
So that is the difference. See, institutions that were taken over prior to 2004, those teachers who were already working, they would probably get the benefit of the GIA 1994. Even in those colleges, I'm not sure, subject to what they may argue, even in those colleges, If there are now teachers joining in after 2004, I wonder whether they can get the same scale or whatever.
No, they won't get it.
Sorry?
They won't get it.
So
Post
there will be a
2004.
cutoff. You see, when one scheme is replaced by the other, there will be a cutoff. So we shouldn't compare apples and oranges.
Right.
You pick up some college taken over after 2004, to which 1994 has been extended.
I'll show that. Please see the next document, then I'll come to those colleges.
All right.
The next ballot is 24th of November 2020.
Yes.
Consequent of dismissal of review petition filed by the state of Orissa.
All right.
And pursuant to the order of so and so, government has been pleased.
No, this is some Vindhya Vasini Junior College.
No, this is only for the purposes of.
No, look at that post. My question to you itself was because of the third column. I saw this.
Yes.
I went ahead. The advantage of digital file is that we can go ahead of you.
Well, I'm only showing this document for the purposes of showing.
No, in fact, my question was because of this document. I realized that there are some colleges where they may have taken it over before 2004.
Well, I'll see that in the IA, but let me complete this document, then the counter affidavit stands complete.
All right.
The limited reason as to why I'm placing reliance on page 52 is, in 2020 November, that is post Anup Senapati, judgment of Supreme Court, they have granted even 1994 GIA.
No, because this was a pending dispute from much earlier, sir.
Well, same is the decision of Lord Justice Hadangi.
Yes.
Justice Hadangi's decision is a court decision, and granted, it was given in 2015.
All right.
Now, Lord, please check that IA.
Give us the IA number 1062.
Yes. 1732.
1732. (1732) in this writ appeal 401.
But IA is 1732 in writ appeal 401. Filed on 6th of September. This is that IA which my lords have seen last occasion and put Learned AG to notice in the last order.
All right. Maybe it's not scanned. Sorry. Yes.
But the page 4 of that internal page 4.
These are various, your lordships have it, Milord?
Yes.
This is the first order is of 30th of January 2012.
Correct. Biju Patnaik College of Science and Education.
Yes.
Correct.
Now, my lord, the paragraph 4. This
No, this itself is dated 2012.
12, which is after the repeal of 1994, that is 2004. And at serial number 4, this approval order is subject to the stipulation that under paragraph 21 of the Orissa so granting order.
Which page are you reading, Mr.
No. See, this is pursuant to some litigation.
Yes. That's the first line.
These are all first pursuant to litigations.
Yes. That's the
So
point.
obviously they started litigating. What must have happened is this. When in 2004, when that 1994 got repealed, they must have said all of you will get only under 2004. People who were already there working from 1994 and earlier must have said we can't be deprived of the benefit of 1994 till 2004. That must be it.
Lordship is absolutely right, my lord. These are all those cases.
All these orders are consequent upon some orders by a court of law.
No, and the takeover must have been prior to 2004.
Quite right. But here, today,
or even if it was 2004, there will be people working from 1994. I don't know how it was. We have to see those paper books. Actually, the AG can tell us.
Yes. But these are all, my lord, consequent upon some orders by some court of law.
I know. See, they're all, you look at the years of the lecturers, all 90, 90, 91.
Yes.
And they're all being given salaries of 94, 96, 98 by these orders.
In our case, the lecturers are of 1994 only. 94, 95. The litigation is continuing.
Date of takeover is the question. Date of takeover of these institutions is the question.
My lord, there is one, if it can help, my lord, please see page 8, internal page 8.
8, all right.
There, the same constraint was faced because it was under municipality. This is of 3rd of April 2014. In pursuance of the order of the High Court by so and so, the approval is accorded provisionally to the appointment of one teaching staff of Mithila Panchayat College. But even Panchayat is sought to be prohibited like a corporation under 7C.
But again, pursuant to High Court order.
That's right. Date as mentioned below, direct payment of salary costs subject to the provisions of so and so, GI order 1994 in 2014. So, my lord, all these would be pursuant to the orders of the courts. But, my lord, but for the non-decision by the government for all these years, 6 years, because in single judge order is 2015.
So the important thing here in all these cases is actual date of takeover.
I'm sorry, but there is no takeover in these matters. In fact, these are all non-government institutions which are given a support by the government. And that support becomes entitled under the 1994 Grant-in Aid order for the first time. And under that order, everybody has to apply in a certain time. I will show you a paragraph from Senapati's judgment where the Supreme Court itself recorded it has to be done at the relevant time. In our cases, it has been done at the relevant time. These are not government. There's no takeover as government colleges.
What I think what my lords meant by taking over is when did you come into the fold?
Yes.
Now the question
it's
is
not a question of takeover.
The Supreme Court has held in Senapati's judgment that that you have to look at when you applied, whether you applied in the relevant time or not, which the department itself has recorded that we applied at the relevant time. They didn't take a decision for so long. And that is why the matter went to court. So when your lordship looks at it, you have to see that the relevant time of application for Grant-in Aid or in aid was under the 1994 Grant-in Aid order. And that is why throughout the government has dealt with it. In fact, your lordship will be surprised to note, even the 2004 Grant-in Aid order was repealed in 2009. Then how can they give us 2004? Then even 2004 should go, if that was the logic. And the first order they passed in our matters to give us the Grant-in Aid is passed in 2017. That is the problem. So they are still assuming that our case is covered by the 1994 Grant-in Aid order because we originally applied under the 1994 Grant-in Aid order. And that is recorded at page 33 of the counter affidavit in the report of the director. He records that lordship may just see page 33.
Let him finish. Mr. Sandal, just let him finish.
I'm sorry.
So, well,
Sorry, Mr. Tripathi.
I have shown the documents, my lord, which would indicate that it is the consistent stand of the government before the decision of Lorraine single judge and post decisions that what was sought to be granted to these two colleges is 1994 and none else. That's one. If, my lord, I am successful in persuading my lords that the decision of Lorraine single judge, in which he is directing the government to take a follow-up action within 4 weeks, qua the decision of 13th of August 2013, and that is referable to 1994, my respectful submission to my lords would be that this repeal, my lord, business of 1994, which is sought to be canvassed today for the first time, after having, my lord, that judgment attain finality, because there is no challenge of that judgment now, my lords would ignore that plea, and rather, my lord, there are two decisions of the Supreme Court on this subject. One, rights already determined can be invalidated on the strength of the subsequent declaration of law.
What is the judgment?
But this is Union of India versus Madras Telephone.
Versus Madras High Court.
Madras Telephones.
Telephones.
And the second, my lord, on the doctrine of overruling principles. Overruling by a subsequent judgment cannot dilute the binding effect of the decision already determining the rights inter se. But this is, my lord, Nilima Srivastava versus State of UP, rendered just 2 months back. Well, the first one is Union of India versus Madras Telephones.
Oh, 3 copies has come. Nilima Srivastava. The other one I haven't got a copy.
But kindly see the last page.
No, same Nilima Srivastava. What you are referring to? Nilima Srivastava. There is one Madras Telephones. You have to give us one more copy of Madras Telephones.
Mr. Tripathi, what is the report?
This is, I have solved the copies in your office today in the morning.
No, I'm working from home. Can you just give me the
of Madras Telephone, is it? Okay, all right, all right.
It is taken out from the date. There is no reference. This is Civil Appeal 4339 of 1995.
Yes.
Well, the last page. Last page, the third paragraph. This court has clearly clarified the position in the aforesaid judgment. The observations made by this court while disposing the appeal in Paravanam are also pertinent. This court clearly laid down the principle that the seniority fixed on the basis of the directions of this court, which had attained finality, is not liable to be altered by virtue of a different interpretation being given for fixation of seniority by different benches of tribunal. Consequently, the promotions already effected on the basis of the seniority determined in accordance with the principle laid down in the judgment of Allahabad High Court cannot be altered. Having regard to the above observations and clarification, we have no doubt that such of the applicants whose claim up to seniority and consequent promotion on the basis of the principles laid down in the Allahabad High Court judgment in Parvanand Lal's case have been upheld or recognized by the court or tribunal by a judgment and order which have attained finality will not be adversely affected by the contrary view taken in the judgment reported by so and so. Since the rights of such applicants were determined in a duly constituted proceeding, which determination has attained finality, a subsequent judgment of a court or tribunal taking a contrary view will not adversely affect the applicants, in whose case the orders have.
You'll have to speak to the mic. I think they can't hear you very clearly. The mic. Just pull the mic towards you.
Well, that's that para. And in Nilima Srivastava, the second one, but here they have invoked the doctrine of overruling.
Right.
Paragraph 30, my lord, which my lord would see at page 7.
Yes.
It becomes absolutely clear from the above clarification that the earlier decisions running counter to the principles settled in the decision of Uma Devi will not be treated as precedents. it cannot mean that the judgment of a competent court delivered prior to the decision in Umadevi and which has attained finality and is binding inter se between the parties need not be implemented. Mere overruling of the principles on which the earlier judgment was passed by a subsequent judgment of a higher forum will not have the effect of uprooting the final adjudication between the parties and set it at naught. There is a distinction between overruling of a principle and a reversal of the judgment. The judgment in question itself has to be assailed and got rid of in a manner known to or recognized by law. Mere overruling of the principles by a subsequent judgment will not dilute the binding effect of the decisions on inter parties. But the reason why I am placing reliance on this para is because of the London AG's submission on Anup Senapati. Senapati decision is rendered in 2019. London single judge decision, which has become final, was rendered in 2015. 16th of April 2015. If I am correct in my submission before my lords, that the decision of the London single judge in the writ petition was 1994. And that was in fact the decision that was taken by the Principal Secretary to Government on 13th of August. Then, my lord, since the decision has become final, there is no challenge in the manner which is known to law, but that's the observation here. And they have withdrawn that appeal before my lords. Therefore, London single judge, the contempt jurisdiction, my lord, is invoked against them rightly. And Chunnilal's principles, my lord, would have to be seen now in the correct perspective. If, my lord, there is no, the order of the contempt jurisdiction, contempt court is only a reiteration of what is contained in the earlier order. There is neither a fresh adjudication. Well, Chunnilal forbids the contempt court not to undertake the exercise of a fresh order. But what is sought to be done by the contempt court is that it is only reiterating the order that was passed in 16th of April 2015.
Yes.
And to that extent, my lord, I would respectfully submit that the writ appeal is not maintainable, because the only way that it could have been maintainable by invoking section 19 of the Contempt of Court Act, in which, my lord, it is settled that till such time the contempt proceeding is not come to an end and the contenders are not visited with a penalty, a court cannot interdict the proceedings in contempt. And that seems to have been, my lord, the effect of the Supreme Court order in these proceedings itself. Now, my lord, my last submission before my lords would be that in the event my lords would see that there is some technicalities coming in the way, please, my lord, see to it that the justice is rendered to these people. They are teachers who have been imparting education for the last decades. They were getting 30,000. You entertained, you gave them a fond hope. You took all steps in furtherance of a decision. Today, you can't say merely because the word is applicable on that technicalities, a state government, my lord, cannot be seen to be playing with the life of this way, in this way.
All right.
I'm grateful.
All right. We'll hear Mr. Sangal and then we'll come to the AG.
Most of them.
Yes.
But I'm not going to repeat one argument which has been made by Mr. Tripathi because he's ably done it regarding the documents. There are only one or two documents you'd like to show.
No, one thing I didn't quite understand, Mr. Sangal. Some of you are retired teachers, is it?
Not my, as far as I know, the clients whom I am representing is the second one, Vishnu Priya matter. None of them are retired. But
Okay.
that's what I've been.
The interveners were somebody else then. The interveners in the first one.
No, interveners. I'm not representing the interveners. I'm representing the second petition. But I'm relying on documents of the first petition only because
correct.
that is a complete set.
Fair enough. Fair enough.
Now, my lord, I have to answer two questions. One
Yes.
is the question of repeal of the 1994 granting aid order.
Right.
And how your lordship would be able to issue an order supporting the single judge's findings and the operative part in view of the repeal. Now, just one question which your lordship had asked was that what is there to show that they decided on applying the 2004 order? Now, my learned friend has already shown the first 1/5/2013 letter, the 23/5/2013 note, the 13/8/2013 note, which has been relied upon to give the single judge's order, then the 28th of October 2015 letter. These are all on record with the counter affidavit, which clearly show that at all relevant time, 1994 granting aid order was being considered as the applicable. It's not a question of what is to be used, but applicable. Now, Lordship may see that for the first time in 2017, there is a note which comes up, which is put on record by the learned AG, and it is part of the rejoinder. If your Lordship will see the rejoinder at page 23.
Rejoinder the first matter.
First matter, I'm relying only on the first matter, because otherwise it will be too much running around. Now, the first letter, the first note at page 23 of the rejoinder shows that for the first time, they mention, this is in the third para in the first noting 6, it says, since these colleges are eligible to get notified under GIA Order 2004 as per verification report of director. So for the first time in 2017, which is more than 2 years after the single judge's order, they first time refer to 2004 granting aid order. And that is interesting to note, because in 2017, even the granting aid order 2004 had lapsed. It had been repealed. Then you had the 2009 granting aid order. So if what the learned AG is arguing that 1994 is gone, then 2004 is also gone. Now, is he going to say that the education department continues to give you granting aid under an order which they prefer rather than what is relevant at that time? It is not that issue. It is the problem is that you have to look at a case as to when it arose. Now, Your Lordship, I just point out one more thing, and that is page 33 of the counter affidavit in the first matter itself, which is a part of the report of the director of 13th May 2013, and that is page 33.
Page
33 of the counter affidavit is part of the report given by the director prior to the last note of 13/8/2013. Lordship, may just see on the top, the fourth para, which my learned friend had also read. It's very important because it says, may I read, my lord?
1 minute, 1 minute.
Yeah, please.
Tell me the page 30?
33 minutes.
This is part of that report.
That is the second page of the report.
Correct.
And
We got it.
the fourth para from the top.
Yes.
This college has submitted application for availing GIA at the relevant point of time under the provisions of GIA Order 94. This is what is relevant because both the colleges had applied at the right time under the GIA Order 1994, and no decision was taken by the government on that. That is why I say that the relevant granting aid order which has to be applied to these cases is the 1994, because the application was made under that time. The government can't sit on it for umpteen years and then say, no, we considered you in 2017, so we will give you what is relevant at 2017, or even under the...
But isn't that, Mr. Sangal, isn't that inevitable? There are so many pending applications
Correct.
Now, all pending applications can't be considered under the earlier repealed scheme.
No, they have to be considered at the time when the applications were made, and not, may not, I mean, just.
No, I'm just saying, if it is, while the applications are pending, a new scheme comes about, how can you say that this application should still be considered under the old scheme?
Because if the application is staying, is not being considered because of a defect in the application or some condition not being fulfilled, that is fair enough. But where everything is complete and they have looked at it, but they don't take a decision because of some other factor which is not in the control of the
So there are others who went to the court. So
Yeah.
this is the whole point. There are others who went to the court saying the government is sitting over my application.
Correct.
Please ask them to do something.
Correct.
That litigation is going on and on. That's where all the orders read by Mr. Tripathi.
Correct.
In those kind of cases, then the court steps in and says, no, you should have granted this. Then it can't be, prospective, retrospective. So there are court orders in terms of which then it is granted.
I agree. In fact, my lord, just
And I'm sure, yes.
My lord, I'm just pointing out that the Supreme Court in the Senapati judgment is very categorical. And in para 24 judgment, it says very clearly that, my lord, may I just give the citation, because the copy which is filed by the learned AG is only an extract and it is not the complete set. And it doesn't contain the paragraphs I'm mentioning. So I just give the citation.
Right.
This is 2019, then volume 19, SCC 626, State of Orissa and another versus Anup Kumar Senapati. This was a big batch of matters. And
Mr. Sangal, which paragraph you want to learn?
my lord, the SCC online, it should be para 24 and 25.
Your lordships will have it at page 123 of my compilation. That
Oh,
memo.
you have compiled. Okay. Sorry,
Yes, I filed the whole judgment.
Okay, fine. I'm sorry. Page 125.
Yes,
Yeah,
of the compilation.
Yeah,
Anyway, 123.
120. I'll just mark it. Doesn't matter.
Anyway, I have marked it. I will deal with it. Don't worry.
Okay. Now, my lord, the para 24, the judgment was considering the same issue. Whether once the 1994 granting aid order is repealed, what happened? They said, no, you can't go by 1994, you have to go by 2004. But they said two more important things. One, in para 24, they said, a non-government educational institution eligible to be and desirous of being notified as an aided educational institution has to apply in Form A. The application shall be made within 3 months. I'm sorry.
No, carry on. Other.
An application shall be made within 3 months from the date of completion of the qualifying period of eligibility. The director may extend the period for good and sufficient reasons. Further requirement is provided in para 9 that of workload and other yardsticks, the workload should be determined, and they go on and explaining what has to be required. Now, Lordship, you see para 25. This is crystal clear from the scheme of the 1994 order that the granting aid has to be claimed within the period prescribed, and the director on good and sufficient cause may should extend the period. Otherwise, it cannot be claimed. Even after completion of 5 years and 3 years qualifying period, as the case may be, there is no automatic accrual of right. Now, today in our cases, what we have done is we have applied in the time granted. We can't claim outside. So anybody who goes to claim later on may have problem. We have claimed in correct time, and that is shown at page 33, where the director records that they have applied at the proper time. Now, once we have applied for the proper time and no defect is found in the application and no reason is found not to grant it, excepting for the fact that it was owned by the OHPC, therefore I say that the applicable granting aid order, whenever you may give, will have to be 1994, because at the time when I made the application and when the government should have considered it, it was the 1994 granting aid order, not the 2004 granting aid order. Now they can choose, they can pick and choose and say A college will give in 94, B will in 2004, C in 2009, or in 2018, 17, whenever the new granting aid order comes. That it permits the government to discriminate between the colleges which are qualified. And that is why in their own documents, in all the letters, and which my learned friend showed, Justice Mr. Tripathi showed, very clearly they all considered it to be 94 because they were all considering that the applications were being made, had been made at the appropriate time. The second set of applications which they asked in 2015 were asked because they said, now look at them again. And that is why as the second set of forms were asked, which have been mentioned by my learned friend. So therefore, the second was set was only to reconsider the whole issue. But the original applications are made at the appropriate time as mentioned in the director's report. Now, once I make the application,
private education.
I can't, and these are all private institutions, these are all non-government, because once you are government institution, there is no need for granting aid, your salary, etc. is already being paid by the government. It is only in the case of private non-government institutions of various natures that the granting aid is given to support the payment of teaching and non-teaching staff. And therefore, I say that this issue of 2004 having repealed 1994 is really not applicable in this case, because our applications were in appropriate time immediately after we qualified. There is not a single mention anywhere in any of the documents of the government that these colleges did not qualify when they made the application, or that they did not qualify the requirements which are mentioned in Senapati's judgment, or that they should not have been given for these reasons. In fact, the reason why they did not give, that the OHCP support, is actually not considered by the Supreme Court in Senapati, because that is it's a extremely singular, non-repeatable case where this has happened. It would not happen otherwise, because most of the colleges are either private or government, and it is not in the nature that you have support from somebody else. In fact, even in the support by this doesn't make it a government educational institution. Now, Your Lordship will note three things and then I stop. I don't want to go beyond it.
Yes.
One, the Senapati judgment very clearly says that you must apply at the proper time, which in our particular case has been done as shown at page 33 of the counter affidavit. Second, that we must make it within the time prescribed, which has been done. There is not a single document by the government filed or in the record which shows that we did not qualify at the time of making of the application as per the Granting Aid 1994 orders requirements and Orissa Education Act requirement. We had qualified completely. It was only a question of their being willing to give us the granting aid. That is why the government also in all their documentation considers that yes, it is the 1994 which has to be given. They do so in 2013, they do so in 2015, and it is only in 2017 when suddenly somebody decides that no, they qualify under 2004, so let's give them under 2004. Now, even that, if that argument is there, it's incorrect, because in 2017, even 2004 was not there. So again, you are stuck with the same problem as to what to do now, because again, 2004 has been repealed by the 2009 Granting Aid order. Therefore, I say that it is the time of making of the application, which is, of course, has to be complete in all sense. And there is not single letter, note, or a report of the Education Department which says that these institutions did not comply with the requirement of 1994. In fact, to the contrary, they say that yes, they do comply. If Your Lordship will see the report, it says at page 33 of the counter affidavit, it says yes, they do comply with everything. They have been set up properly. They have got the area, they have got the teachers, they have got the facilities. Everything is there, and that is why the government, in fact, treated this as a case of 1994 Granting Aid order. Now, one thing more, my lord, and then I'll finish. If Your Lordship will see, much has been made out of the phrase relevant Granting Aid order, and that is in the 31/8/2000. 31/8/2013. Order Lordship may see page 32 of the writ or page 40 of the counter affidavit. Even that is good. Page 40 of the counter affidavit, the Lordship will see. In this note sheet, which is there, now Lordship may see page 39 of the counter affidavit, the note sheet. Because this is the note sheet which is on which the judgment is said to be based. There is a writ judgment. And I like your Lordship to also give me the liberty to read the 1/5/2013. The Lordship may see the last paragraph on page 39 of the note sheet. May I read, my Lord?
Yes, please.
In order to overcome the above difficulties, meeting of the committee was held on 1/5/2013, wherein Additional Secretary, HE Department, Director, Higher Education, GM, HRD, OHPC were present. The proceedings of the meeting is at page 172C. It was decided to bring the two colleges in the GIA fold under the relevant provisions of the GIA order. Now, please stop at this place and go to page 30 of the same counter affidavit.
Yes.
Now just see the difference in the words. At page 30, what it says is, second paragraph, after discussion, it was decided to bring two colleges into the granting aid fold. Sorry. I'm sorry.
Same thing that Mr. Tripathi read.
No, same thing. But I just want to point out why that. What is the meaning of that relevant provision?
Right.
Because that is where the question arose.
You want to interpret it in your favor to say relevant in that context meant 1994.
No. I don't want to interpret anything. I just want to read the two lines on two documents to show what it actually means.
All right.
After discussion, it was decided to bring the two colleges into the granting fold by extending the provision of 1994 granting aid rule to cover these two colleges. Now, please see page 39. It reads, it was decided to bring the two colleges under GIA fold under relevant provisions.
Yes.
Now, they are quoting here, when they talk of the note sheet of 13th August, they are quoting from the 1/5/2013 meeting. And therefore, when they say relevant provision, they are talking of what was mentioned in the note.
Mr. Sangal, it still begs the question that I posed to Mr. Tripathi. All right.
Yes.
Assuming that they did have only this 1994, they meant only this 1994, they wanted to give only 1994.
Correct.
In law, is it legally permissible for them to do so?
Yes, if it is being considered as a case of
there is no 1994 scheme. What are you going to give it under?
No, they will have to give, because they have to act as if they are deciding the application which was made in under the granted aid 1994.
We can't rewrite facts, can we?
No, we are not rewriting, because that's what they are doing. They are considering the 1994 applications, which they are now deciding. So the facts that the law as it applied when the application of 1994 was made and under the granting aid 1994, that will have to be applied, not a subsequent rule. That is why 1994 will be granted.
All right.
That's all. I'm obliged.
Okay. Mr. Parija, do you want to reply on Monday?
You have to unmute. You have to unmute, Mr. Parija.
Oh, no, he says he can't get through.
Yes.
Now, my lord, just see page 78 of my compilation. Let me deal with Mr. Sangal's argument first.
No, my lord is asking you whether you are.
Yeah, whatever. As your lordship pleases, my lords.
No, you said you were unwell, which is why I was asking.
No, my lord, then let me take your lordship. Since I'm already sitting all day, might as well. My lord, actually, since morning I got tested for dengue and I got tested for COVID. All those reports have come negative. So my mind is now free.
Okay, okay.
I don't know, nowadays, you have cold and then everything gets into your head.
Correct.
And my lord, I am envious of Justice, your lordship brother, Judgment Justice Rautray. He is learning fast to now work without a paperless court.
It's actually quite simple. It's quite.
I know.
Simple.
I will try and ask.
I think Mr. Sangal is quite adept at it, if I'm not mistaken.
Well, that's what I said. Your lordships had done it well before the pandemic. Well, would your lordship see page 77 first? Because the argument is that since 1994 applications were made, therefore they should be considered. Now, kindly see, my lord, page 77. This is the report of the college. My lords have it, my lords?
Yes.
This is the report of colleges governed by OHPC. That's a little important. And if my lords kindly have it, my lords, kindly see page 78. This is the paragraph in which he relies upon. My lords have it?
1 minute.
2, 3. This is the third paragraph on the top. Page 78.
Report on colleges governing body.
Lordship, please. Report on colleges governed by OHPC.
Page 417.
And if my lords kindly see the fourth paragraph, that's what my learned senior read.
Yes.
This college has submitted an application for availing GIA at the relevant point of time under the provisions of GIA 1994. That's the line that was read. But what was not read is not. But no government notification declaring the college as aided one has been issued due to the reason that the college is being managed by a public sector undertaking and is not eligible for GIA under the provisions prescribed under subsection 6 of section 7C of the Orissa Education Act 69. So therefore, my lords, in 1994, this college was not entitled to any grant in aid. And if my lords kindly comes to page 81, your lordships will see the act just 2 pages thereafter. At the foot of the page is 7C. My lords have it, my lords?
Yes.
And kindly turn over the page. 82, again foot of the page, no educational institution imparting any other courses of study except those in subsection 5 shall be eligible for grant in aid. Educational institutions established and or managed by urban local bodies, Jilla Parishad, Panchayats, so and so, public sector undertakings or statutory bodies shall not be eligible. So therefore, my lord, these colleges are not eligible for GIA ever in 1994. Now, my lord, for the first time, they were to be brought into the fold was in 2013. So just before that report at page 77, your lordships will see one document which is paginated as page 76. If my lords have it, my lords?
Yes.
This report is being forwarded by the director to the additional secretary to the government.
Yes.
My lords have it, my lords? Kindly see last 4 lines. The governing bodies of the 2 colleges are submit proposals to include the 2 colleges under the GIA fold, provided, kindly note this, provided government in principle agree to extend the benefit of GIA available under GIA 1994. So this is subject to the government taking an in principle decision. Much has been said about it. Now let us see page 75, because that is what Mr. Tripathi read, that the additional secretary was a part of that decision-making process. Your lordship knows, my lord, there are several tiers of decision-making process in the government.
Right.
And now would your lordship see what was the actual decision taken by the government?
Said agency after taking over.
Lordship pleases. My lord, before going that, let us see, my lord, whether at all a content proceedings lie. Kindly see page 12. This is the order of the learned single judge dated 16/4/2015. My lord, the honorable single judge records whatever is there in the minutes and says that please, would your lordship see page 16? That is the direction in that view of the matter. My lords have it, minutes.
Yes.
In that view of this matter, this court disposes of this writ petition, directing the government to take immediate follow-up action in compliance with the decision taken on 13/8/2013. The entire exercise shall be completed within a period of 4 months. My lord, 13/8/2013 is at page 66. The noting of the additional secretary starts from the previous page. 65, last paragraph.
I know, relevant. This is again brings us back to relevant.
Absolutely, because he is also conscious. GIA order and authorize the director higher education to so and so. And the secretary, which is the most important order, says that bring it under the GIA fold. There is no 1994. So let us not presume what the secretary meant, what the secretary thought, what were the interdepartmental correspondences. Your lordship knows, my lords, various correspondences take place, various notings are made in the file, and finally the government arrives at a decision. Now, my lord, your lordships have been shown several pages where the government has also extended the benefits, etc. Would your lordship straight away come to page 102? My lord, I agree. There was at one point of time lot different judgments went on different directions. And if your lordship sees page 102, the relevant part is 110. This is Anup Senapati's judgment.
Right.
And this will clear all your lordship's doubts. May I read the first paragraph?
Yes.
The question involved in the appeals is whether the employees are entitled to claim grant in aid as admissible under the Orissa non-government colleges, junior colleges, higher secondary schools grant in aid 1994. After its repeal, kindly note, my lord, after its repeal in the year 2004, by virtue of the provisions contained under the Orissa non-government college, junior colleges 2004, herein after referred to so and so. The 2004 order has also been repealed by the 2008 order. This is the question your lordships are always asking. This is what your lordship was being bothered about. Now kindly turn to page 118, paragraph 14. Internal page 642 of the report.
Yes.
The provision as to repeal and saving contained in para 4 of the 2004 order is extracted hereunder. The Odisha non-government colleges, junior colleges, higher secondary education grant in order 1994 is hereby repealed, save for the purposes mentioned in subpara 1 of para 3. Notwithstanding the repeal under subpara 1, the private educational institutions, kindly note, not institutions, which are in receipt of grant in aid from the government under the order so repealed immediately before the commencement of this order shall continue to receive such grant in aid as if the grant in order 1994 had not repealed. So therefore the cutoff is once it is repealed, everybody who was getting will continue to get and no new. Your lordships will then kindly see page 121. Paragraph 20. My lords have it?
Yes.
Paragraph 20. Mr. So-and-so appearing on behalf of the state of Orissa submitted the High Court as well as the State Educational Tribunal heard and have acted in gross violation of law to entertain the claim by the employees The applications were filed by the tribunal during the year 2011 and 12 to claim release of grant in aid under the repealed 1994 order. The applications were filed belatedly by the employees. They were not entitled to grant in aid under 1994 order. The grant in aid cannot be claimed as a matter of right. There are various factors to be taken into consideration for releasing grant in aid. No representation was filed by the employees at the relevant point of time. Relevant point of time would always include Milord prior to repeal. And there have been filed representations, writ petitions, original applications belatedly. Now, Milord, this line is very important. Divergent views have been taken in different cases by the High Court. The High Court and the tribunal have opined in some of the impugned judgments and orders, and they refer to all of them, that the employees are entitled to grant in aid under 1994 order, whereas, Milord, this was really the change. Whereas Loknath Behra versus State of Orissa, Milord, this was delivered on 11th of September 2018. A division bench, actually it's a single bench of the High Court, has opined that grant in aid cannot be claimed under 1994 order after its repeal. This is Justice Prasad's judgment. We have been taken through the scheme of the Act and the provisions of the orders issued thereunder. Milord, may I read the next paragraph? The learned counsel, that will give you a lot of the picture, what was the Supreme Court dealing with. The learned counsels appearing on behalf of the employees have submitted that a right has accrued to the employees to receive grant in aid under 1994 order with respect to posts which were in existence and appointment have been made prior to 1/6/94. Even in that case, on completion of 5 years or 3 years, as the case may be, the tribunal has allowed the applications in another matter in the year 2010. Therefore, writ petitions were filed on the ground of parity to claim similar relief, and representations were filed under the filed on the ground that the order of the High Court, which was illegally rejected by the state government. Thereafter, original applications were filed to tribunal, and the same has rightly been allowed. The decision of Loknath Behra does not lay down correctly, as once a right has accrued and has vested, a claim
These are their contentions.
These were the contentions of rival parties. So this is what paragraph 20 was our contention, 21 was their contention.
Right.
Now your lordship may kindly see para 24 and 25, my learned friend read. Am I audible?
Yes, yes.
Yes, para 24 and 25 is what my learned friend read. And now would your lordships come to page 124, para 27.
Right.
In our opinion, my lordships have that line minutes?
Yes.
In our opinion, the prayer made to release grant in aid under 1994 repeal order, on the 1994 order after its repeal was misconceived and would not be possible for any government within its economic capacity to release the grant in aid retrospectively. Delay by itself defeats the rights, if any, to claim grant in aid, which was dependent on the option of the institution to apply for it. They may choose not to apply for the grant in aid, as it comes with several riders as imposed by the government. Thus, the original applications filed belatedly after the repeal order of 1994 could not have been entertained at all. And the employees filing applications after the repeal of 1994 order cannot be said to be entitled to any relief owing to laches having slept, assuming your institution was covered, yet you did not apply. Here, Milord, institution came in 2013, so there was no question. The next question which we take up for consideration is concerning the effect of repeal of 1994 order by the 2004 order. The provisions contained in para 4 of the 2004 order have been repealed in the 1994 order, save as purpose of para 3.1. Para 3.1 provides every private educational institution being a non-government college, junior college, higher secondary school, which has become eligible by 1/6/94 to be notified as an educational institution under the 1994 order shall be notified by the government as required under section 3B of the Act and shall be entitled to receive grant in aid by a block grant under 3.2. The proviso to para 3 makes it clear that a college to be eligible to be an aided educational institution must not have to, your lordship, skip all that. No, that's not very relevant. Then your lordship, then the Honorable Supreme Court says what is the effect of repeal. And so saying, my lords, kindly come to now para 32 at 129. My lords have it?
Yes.
It is apparent from the aforesaid discussion that if one is unaffected by a repeal statute, right acquired or accrued and not and not a mere hope or expectation or of liberty to apply for acquiring right. So either you have got a right, you have got an order under the 1994 GIA before 2004 or nothing. There is a distinction in making an application for acquiring a right. That's what my lordships are saying. You may apply, that's not enough. If under some repealed enactment, a right has been given, but an investigation in respect of a right is necessary, whether such right should or should not be given, no such right is saved. That's what fell from your lordships.
Correct.
Right to take advantage of a provision is not saved. After repeal, an advantage available under the repealed act and obtain relief is not a right which is saved. When the application was necessary, it was discretionary to grant relief and investigation was required whether the relief should be granted or not. The repeal would not save the right to obtain such a relief. The right of preemption is not an accrued right. It is a remedial right to take advantage of an enactment. The right of a government servant to be considered, your lordship may leave that. Now kindly come to 34. In the present case, it is apparent that there is no absolute right conferred under the 1994 order. The investigation was necessary for whether granting aid was to be released or not. It was a mere hope and expectation to obtain the release of granting aid, which does not survive after the repeal of the provisions of the 1994 order. Given the clear provisions contained in para 4 of 2004 order, repealing and saving 1994 order, it is apparent no such right is saved in case granting aid has not been received at the time of repeal. Now, my lord, when did this institution come to the granting fold? 2013.
Right.
All this is over in 2004. The High Court, let me read the next paragraph. The High Court in Loknath Behra has rightly pointed out that due to repeal of the provisions of the 1994 order cannot be invoked to obtain granting aid. The High Court has rightly referred to. May not they refer to all these judgments. Then para 38. Thus, there was no vested, accrued, or absolute right to claim granting aid under the Act of 1994 order. Mere fulfilling, because some people said we had applied before the repeal and therefore we should have got. The Supreme Court said, sorry, either you have got it or you have not got it. My lords may now kindly come to para 39. This is what is being argued now. It was lastly submitted that concerning other persons, the orders have been passed by the tribunal, which was affirmed by the High Court. And your lordship may add, even the Supreme Court. And granting aid have been released under 1994 order. As such, the ground of parity, this court should not interfere. No doubt, there has been a divergence of opinion, kindly note this, on the aforesaid issue. Be that it may, in our opinion, there is no concept of negative equality under Article 14 of the Constitution. In case the person has a right, he has a right to be treated equally. I'm heavily relying on this one. But where a right is not available, a person cannot claim right to be treated equally, as the right does not exist. Negative equality, when the right does not exist, cannot be claimed. So merely because I have given this even in 21 and 2021 to comply orders of these of your lordship's court or the tribunal or the Supreme Court, my lord, on the pain of contempt, does not mean they are entitled to the same treatment.
Right.
But I'm sorry. Would your lordships kindly come to page 136. Paragraph 49.
Yes.
It is apparent on a consideration of para 4 of the 2004 order that only saving of the right is to receive block grant, and only in case of aided had been received on or before repeal of 2004, and it shall not be affected by 1994 order shall continue only for that purpose. Thus, we approve the decision of Loknath. Right. Now, this judgment, I think I've given a copy of that 2020 para 15 SCC 546 only on the question of negative equality. A bench of two honorable justices, Justice L. Nageshwara and Justice Hemant Gupta, 2020 15 SCC 546. I think it was handed over on the last date. Your lordship may only note, my lord, in paragraph 13 on the question of negative equality, State of Orissa versus Anup Kumar Senapati has been quoted.
All right.
Now, my lord, see one more interesting fact.
It's okay.
Kindly come to page 170. My lord, against a similar batch of writ petitions, where this honorable court had directed that implemented, and writ petitions were filed after a delay of 800 days, naturally dismissed, my lords, we went to the Supreme Court. My lord, this is a bench of Justice Lalit and Justice Saran. If your lordships have page 170, my lord, your lordships have
Correct.
Kindly see page 171.
Tripathi.
Lordship pleases. Subject to the petitioner state depositing a sum of rupees 50,000 in the registry of this court within 4 weeks, issue notice returnable. Thus the service. Kindly see, my lord, after the diary numbers, etc. Mr. So-and-so learned counsel invited our attention to the judgment and order of 16/9/29, passed in civil appeal number so-and-so and other connected matters. The issue involved in the matter set out in para 4 of the judgment. Your lordship saw this just now.
Correct.
But can I just take half a second?
Yes,
just 10 seconds. Yes, clear my thought.
Yeah. Same. Senapati judgment.
So, my lord, 1672, paragraph 1. Para 1 is quoted.
Yeah, 1 minute. 1 minute.
Yeah, I'm sorry.
Yes. So, yeah, we saw that. Actually, because of Senapati, they've now condoned all the delay and...
800 days, my lord. 800
Correct.
Now, my lord, with great humility, come back to the order dated 16/4/2015 of the learned single judge.
Yes.
And, my lord, your lordships have seen Justice Arun Mishra has several paragraphs saying that there were divergent views.
Right.
And therefore, there were divergent judgments. And therefore, there were divergent compliances. It all changed after Anup Senapati really.
Correct.
Now, my lords, kindly see page 12, 16/4/15.
Correct.
That is the order.
Yes.
And, my lords, here there is no direction at all.
Correct.
My lord, I don't see, except quotations of various government interdepartmental correspondences, your lordships have decided nothing.
Correct.
All that your lordships have said is, you take a decision, take compliance action on 13/8/2013.
Yes.
My lord, I'm sorry, my lords. One can't presume that 13/8/2013 meant 2014. Right. 1994, I'm sorry. GIA 1994.
Correct.
So therefore, where is the contempt?
Yes.
I'm deeply obliged. Your lordships have given me a very patient hearing.
All right. So orders
I'm
reserved.
sorry, my lords, if I was not able to assist your lordships.
No.
But I was very afraid of Mr. Tripathi to ask for time in the first instance. Deeply obliged.
Thank you. All of you. Orders reserved. Right.
My lords would be desiring to file some written submission.
Do you want to? Then, if you want to, say if parties so desire, they can file the written submissions within 1 week. All right.
Great.
Deeply obliged.
All right.